Okay, awesome. Yeah, that was a long one. Did you guys listen to the whole thing or?
Yeah, pretty much. Felt like the judge was getting fatigued there at the end for sure. Um, Seemed to me also that Kirkland and Ellis probably need to be a little bit more prepared.
Yeah, it's hard. Yeah, I would try to make sense of it myself. I'm not sure how these hearings usually go. David would be the one better to speak, obviously, than me, but we'll get David up here. Actually, I just saw him. But yeah, I just kind of dwindled towards the end there, and kind of they hit seemed like they hit a wall at 3 hours. So I was thinking it was going to go for four, but then I was like, okay, no, this has to end. It's not really productive anymore. It didn't seem, but I'll let you guys give your takes here. Let me. We get I'll just yeah, I'll get a few more people up, and then yeah, Mary, you do such a great job of running the room, so I'll let you kind of manage things. We'll get questions. We'll kind of do what we did last week or after last hearing. That went pretty well. So I'll focus on getting people in here and kind of getting people on stage. But yeah, you go ahead, Mary. If um, actually David, sorry guys, I think David might be limited on time, so let's maybe get his take out of the gates here before we do questions.
Sure. Clancy, if you want to add me as co-host to help you out.
Hey everyone, can you hear me okay? Hey, can you hear me?
Yes, we hear you.
Okay. Good afternoon, everyone. Long hearing. Um, I think that a lot of things came up today. Some of them are not necessarily good for where this case is headed. I was not happy when the discussion was going on with the examiner where people just kept using the word Ponzi over and over and over again. And I say that because I think that, um, you know, having this sort of cloud of, whether Celsius was a Ponzi scheme and how, how much of it was a Ponzi scheme sort of hangs over the bidding process and, could potentially severely impact, the ability of other third parties to come out and bid on the assets, knowing that there may be a determination that Celsius was a Ponzi scheme, and the retail customers that they think that are getting transferred over are so annoyed and aggravated um, uh, because they're going to get sued for clawbacks that they just take their crypto and go elsewhere. I mean, I don't think I made that point clear. I want to say it again. I want to say it in very general terms. If there's a Ponzi scheme determination, essentially you go back to the beginning of time when the company started the Ponzi scheme, and you would determine your net winners and net losers. And in a normal situation, let's take crypto out of the equation. If you had a normal situation where you invested with Madoff $1 million and you got back $2 million, you'd be viewed as a net winner to the extent of $1 million, and you'd have to give that extra $1 million back to the estate, not under a preference theory, but under a fraudulent conveyance theory. Because once a Ponzi determination is made, all distributions are viewed as being fraudulent transfers. So, obviously that has an enormous impact on the case, has an enormous impact on, what this company could sell for, and the bidding process. And I mean, the other added twist here is, let's suppose, how do you measure a Ponzi scheme here by net winners and net losers? If you deposited one Bitcoin when it was worth $10,000 and you withdrew $60,000, one Bitcoin, 2 years later, are you viewed as being a net winner to the extent of $50,000, even though you're pulling out the same crypto that you put in? I don't think the bankruptcy code has ever addressed really these types of questions. So there's a lot of stuff floating around with the Ponzi scheme, issue that is going to be looked into. I also found it very interesting that the judge asked 2 or 3 times to the debtor and asked them, to be prepared on November 15th to say exactly what, if any, business the debtor is presently conducting. And to me, that's kind of a strange, request. And the judge started off the hearing by asking for an update from the debtor, and the debtor had no update, but then asking them to say exactly what's going on at Celsius. And it might be that the judge is considering the appointment of a Chapter 11 trustee, the conversion of it into a Chapter 7 case because of the fees and expenses, because it is sort of an unusual request to find out, to ask repeatedly. I want to know exactly what business the debtor is doing right now, and to hear from that, and process it to figure out, what would be sort of in the considerations if a Chapter 11 trustee were appointed, or if the case were converted to a Chapter 7. Those questions I don't think were asked, just out of the blue. I think there's a purpose behind those questions. So that was my take on it. I thought that, the judge was frustrated with the pro se motions, and particularly frustrated with the debtor's counsel in not dealing with directly some of the issues. What did he say? He said something like, you can't avoid answering the objections just because you can't blow off the objections just because they're filed by pro se creditors. I thought that was very telling. I think he gave both of the estate fiduciaries today a hard time, both White and Case and Kirkland. With White and Case, I think he gave them a hard time on the examiner motion and the scope, and with the debtors on all the pro se motions. So that's my take of it. At the end of the hearing, the judge was clearly trying to figure out a way to bundle and get these determinations on property rights made. Now, the judge kept referencing stablecoin, but clearly there are other groups out there, such as the borrowers, such as EARN, where similar determinations need to be made. And I was expecting the judge to sort of say, well, in addition to stablecoin, I'm going to have to consider, whether EARN is property or not. And I'm going to have to consider whether the borrower's collateral is property of the estate or not. And let's talk about those issues. Are there representatives of those groups present on the phone to discuss scheduling those issues? He's somewhat, he's trying to deal with stablecoin, but in the background, obviously he wants all these issues on property rights determined sooner rather than later, because if you don't determine them now, you're never going to be able to. You have to determine these issues prior to a sale. Let's put it that way. So that's my take on the hearing. I'm sure I'm sort of in a cloud right now. I'm sure I missed some points, and why don't we just open it up to questions? See what we have.
We have Simon with his hand up. Thank you, David.
Okay, cool. Yeah, it'd be great to just get all the content out by trying to ask a few questions, if I may. David, so the whole thing, like, obviously, Ponzi sounds like kryptonite for all of us and disaster for everyone. Is there any concept that you've ever come across, like an accidental Ponzi? Like, could you start an honest, there's obviously degrees of Ponzi-ness, right? So there's starting a business with the intention of never investing and nothing happening, or there's a concept of investments going wrong and then you having a non-disclosure that leads to you trying to make up the difference and trying to make bets in order to come back, more almost like a Nick Leeson bad trade type thing. Or but is there a concept of different degrees around maybe intent and stuff?
That's a really good question, Simon. I'm glad you posed the first question. That question first to allow me to answer it. I'll tweet this out a little bit later today. I actually sent it on over to somebody else yesterday, but in 2011, Judge Glenn wrote a decision on Ponzi schemes, and it was in regard to a case called Dreyer LLP. Now, Dreyer LLP was a law firm with about 350 lawyers or so, earning 350 hardworking lawyers. But Mr. Dreyer, who was the only equity partner of the firm, basically set up a side little business of committing fraud. And he took one of his clients and told other clients that they were selling notes. And somehow he was an intermediary, and these purchasers sent money into the Dreyer LLP trust account. And the Dreyer LLP trust account had other monies in it that belonged to clients. I mean, other than the fraud money coming in. So the whole sale of notes was considered a Ponzi scheme. The judge labeled the Dreyer case a Ponzi scheme. This judge has a whole discussion of what the ramifications are when there's a determination of a Ponzi scheme. And it's hard. So the answer to your question, Simon, is yes. I mean, there can be a limited Ponzi scheme, I suppose. The business of Dreyer LLP went on as normal, but there was this bank account where it was a trust account where money was flowing in and money was flowing out. And the judge treated all inflows and outflows from that account as being subject to the Ponzi rule of looking at net winners and net losers. So I'm going to post that up later so you all can read it. There's also a nice discussion in that case, and I read it for the first time, first time in many years, a few weeks ago, where there's all sorts of discussions about forfeiture. So the government, obviously, Mr. Dreyer went to jail. The government got forfeiture orders against Dreyer. And there's a whole discussion about the government's forfeiture orders and how they impact bankruptcy cases in general, and in particular in the Ponzi scheme analysis. So, I'll tweet that out later because everyone should read it because, just in case, we go down a path where people start finding that, there was a Ponzi scheme here. And again, to answer Simon's question, a limited Ponzi scheme. I mean, there was business of Celsius, but the question is was Celsius reliant upon new deposits to pay back or to pay yield to old depositors? And if you have that, is that sufficient for it to be labeled a Ponzi scheme? And the answer is I guess it depends on the facts and circumstances. And you can see what the judge considered when he went through the analysis in Dreyer. So I'll tweet that out later so you all can read it.
Also, what's the consequence on Kirkland and Ellis if they have been defending and then it turns out that was a determination? Is this something that they try and avoid at all costs? Is this embarrassing for Kirkland and Ellis, or is this just business as usual?
No, it's highly embarrassing. I mean, this is a case that, is very, very high profile. And if the judge either appoints a Chapter 11 trustee or converts it, I think the judge was very impatient with Kirkland today because he felt that they weren't addressing the issues that were being raised, however inarticulately, by the pro se creditors, and was just trying to blow them off. It's clearly it's not a good mark to have this case be converted or have a trustee appointed. And I think the judge was also very frustrated that these piecemeal issues are coming up in front of them and they're not being answered. I mean, they're not getting proper responses. Let me put it that way.
Yeah. And also there was a lot of talk from the regulators stating that, they are out for the little people. They do want to support the retail investor. They do want answers. But it feels like really we're all on the same team in that this becoming, a Ponzi is just going to be the worst outcome for everybody. And obviously, if it is a Ponzi, it's a Ponzi. But there's clearly, it's clearly not a Madoff. It's clearly,
Right.
yeah.
I mean, I think you're right. I mean, I've been saying it since the beginning that Ponzi is not good. It means that you're going to be chasing people back to 2018, trying to get, let's call it, their net winnings. And again, I say I don't know what net winnings are in this case because of the fluctuation in crypto. I suppose it's really the yield that they received. Not
Well, it would take longer than Mount Gox to examine that in this case.
right. And so, I mean, the goal that I thought everyone was headed towards was, to try and make this very valuable asset of 600,000 retail customers look as valuable as possible to a prospective buyer. Obviously, if you have allegations of Ponzi scheme, and let's just suppose that it's determined that all yield that was paid was a Ponzi scheme, and people are going to be chasing, investors who withdrew their crypto to get that money back. It's not a good thing. It obviously destroys the value of the customer base, the loyalty. I mean, there are many people that I've spoken to that said that they would, just as a matter of principle, if they got pursued for clawbacks, would not keep their crypto at Newco and would move it to some other platform. I mean, that's why I was not particularly. I was unhappy with the discussion and how it was going because people were just throwing the word Ponzi around. And I think that, we are all here and we're all hoping that we can make this company look, as valuable as possible, either for, a community-led plan or for an outside third party. And when you have, Ponzi floating around, it really has an impact. And I think I think we sort of, started heading down a road today where, and I'll say this to Plan C, that where clawbacks of some type are going to be inevitable. I mean, once you start saying the word Ponzi, clawbacks appear. And I mean, I think that, given what I know about this company, I would not be surprised if there was a determination of it being, at least some portion of it being a Ponzi scheme.
Yeah, thank you for that. Yeah, and I remember Frischberg was bringing up the cost cutting and clawback, so he really touched on that a lot. We have Daylong. If you want to comment on that, David, and then Daylong, he's had his hand up for quite some time, and then after him, Bradley.
I'll just say that with Frischberg, you jarred my memory. The judge took that under submission and didn't deny it outright, which to me means that the judge is writing a decision, and I don't know what that decision is going to be about. I mean, like I was surprised. Let me put it that way when the judge said it's under submission and I'll give you a ruling, because it wasn't thrown out of hand. He's obviously writing a decision on it, and there may be some clues as to where the judge is headed in that decision. But I was surprised about that. But I mean, all the stuff that Frischberg raised when Frischberg got up, I mean, had already been raised in connection with the scope of the examiner motion. That's where the real, issues started coming up about Ponzi schemes.
Daylong, go ahead.
Okay, thank you very much. I really appreciate it. For the life of me, and I'm going to keep calm today, I came to this conclusion weeks ago, but it's certainly apparent today. The taint on this company, and David will confirm that that's an actual legal term, not just me being silly. The taint of potential criminality, and at least opening themselves up for civil lawsuits, is so extreme that there's just no way at all there's going to be a reorg that comes from the company itself. I mean, it's just not going to happen. I mean, we need to get past this part. What I can't understand is, I know Thomas DeFiore is listening. I hope some other members of the UCC are listening. Why on God's green earth are we not just begging and begging and begging the judge, the regulators, whoever it needs to be, to say, hey, it is time to get this company out of the hands of the people who own it now. But whether it's Simon and his consortium with Salt, hopefully, I hope they get it. But if somebody bids higher than them, I think Simon is a capitalist. He would be like, I agree. That's a better deal. And as a depositor or a creditor, I'll do better in that capacity too. The time has come where the UCC has to publicly state that we're no longer pursuing a reorg from the people, from the powers that be at Celsius. And that's over. And that regardless of whether or not this company is a Ponzi or not, if the judge really wants to help the creditors, which I think he does, there's no reason to believe that he doesn't want to see this work out well. Even if it's debatable that it's a Ponzi, there's so many, the assets are so robust here that we could have not only a recovery of a new company that Simon takes over, whomever does it, but people could actually get more money back. So even if this is a slight Ponzi, hopefully it's a non-Ponzi at all, but even if it's a slight Ponzi, why isn't the UCC doing everything they can to just sell this company to someone like Simon, who can not only get us whole, but potentially return money to us? I don't understand why the UCC isn't doing that. I wish Thomas and DeFiore would answer that. Hopefully you could speak for them, or at least give us an idea of what they're thinking, David.
I'll give you my sense. I think that you're wrong in the sense that the UCC has reached the determination that a reorganized Celsius.
But David, respectfully, they said the exact opposite on the last time they had an AMA.
Hold on.
Just a sec, Daylon, because just let David speak.
Hear me out on this. I think that they say that. I think that they would acknowledge that the notion of Celsius reorganizing itself is sort of a non-starter. But what you need to do is have a sale process to sell the assets of the company, and then there's going to be assets of the company that are left over. You know, the claims, the preference claims, the claims against Mashinsky and all the others. And you need to have the sale sort of wrapped into a plan so that it's determined where the cause of action resides. So the claim against Mashinsky stays in the Celsius estate. You know, the retail customer platform, gets transferred. I mean, there has to be a plan that sort of addresses the causes of action of the estate and how creditors are going to be treated from those recoveries wrapped into a sale process. I don't think, and I could be wrong, but maybe I am wrong, but I mean, clearly the committee's under a fiduciary duty to consider, any proposal that maximizes value. But it's pretty clear to everyone that there can't be a proposal by Celsius of a Celsius 2.0 that maximizes value, because there's just too much taint, the legal term, associated with the company, number one. Number two, you got all these regulators, and the judge even mentioned it at the hearing today about how the actions of the regulators would probably be or may be exempt from the provisions of the automatic stay. If there are enforcement actions by governmental agencies because of Celsius's past conduct, those are not going to be discharged in a plan. So you could have Celsius 2.0 emerge from bankruptcy, and the next day you have 40 state regulators claiming that the practices that Celsius used in 2018 to 2022 were illegal and still seeking enforcement action. So, my own view is that everyone has sort of come to the belief that the company needs to be sold, but there needs to be a plan process to deal with the assets that are not sold pursuant to the bidding procedures.
I have to imagine that Simon's attorneys, who he spent approximately $10 billion on, have incorporated that into their plan. Simon, am I wrong or am I right? I mean, that's obvious.
Well, no, I kind of agree with you, Daylong. I know the traditional book is that you pretend that you're doing a reorg all the way till the end, and then you sell into the bid. But I feel in this case, it's starting to be a bit counter. I think if everyone knew that this bid was definitely happening, just due to the massive expense of participating in the bid, I think you get more bidders. And so I think people are kind of scared off by the fact that you end up spending so much money to try and win a bid, and then there's this pretense that Celsius are going to reorg on the other side. So I think DeLong's right here. I don't think the traditional playbook is a good idea, and I think the UCC should just tell us how it is. That if the bid is the bid, and anything else feels reckless. Going beyond this deadline that they've set just feels so dangerous at this stage.
In my humble opinion, it feels like the UCC, and again, I'm saying this respectfully, Thomas, because I'm not seeing the same things you're seeing. I understand that. I'm looking at this case from a different prism than you are, but it's time for the UCC. I think everybody listening now, except perhaps them, it's time to publicly state, look, we're going to start the bidding process. There is no way, if the UCC would just say there is no way we're going to accept the reorg from Celsius, that's 50% of where we need to go. And that,
well, we'd also unify rather than all tainting each other around. Oh no, we've got to fend off the bid and we've got to make sure that the Celsius reorg happens. That's creating a lot of noise, and I think it's counterproductive. I don't think it's going to lead to a higher bid.
It's super get out of the way, and that's it.
I was just going to say quickly, DeLong, I completely agree with your sentiment 100%. I'm on board with exactly what you're saying. But from listening to the town hall, from what the UCC said, you had to kind of read between the lines, because what the UCC, and David could speak to this better being a lawyer, but from what the UCC, I remember them saying was, there's a shield. They basically used the word shield a few times. By keeping Celsius, by extending exclusivity for the debtor for Celsius, it shields this process as far as allowing them to move things a bit, maybe streamline some processes through, even though it may not feel like that. So it seemed like, even though the UCC themselves, kind of reading between the lines, they don't see a go-forward plan from Celsius, the debtor, as it's a pipe dream, really. But they kind of want to keep them in the exclusivity position, because it does shield from, they said, from the unsecured, from the preferred equity. They said there's some level of protection there. I don't know. David would be the one to speak to, like, legally. Basically, my question for David would be, legally, what are the benefits of keeping Celsius as the debtor in possession, even though there's no chance of a go-forward company? What's the pros there? And then what are the cons? Because do we really trust, like the UCC can put pressure on the debtor to accept the best bid, but do we really trust Celsius to be the person making these decisions as far as who's the best bid? And are there not conflicts of interest of protecting insiders from going to jail? Like, we need in my opinion, what I'd love to see, and again, I don't know if this is possible within this process, but I'd like to see a restructuring professional appointed, then work with, open this process up and let people bid. Like, that's what we need. We need somebody that is not like all this legal tsunami coming, to put someone that's solely focused on the interests of the creditors, with this creditor committee and a restructuring professional that does not have ties to all these law firms and everything, that's solely focused on getting us out of Chapter 11. That's just my thoughts. I know that, sorry, I'm further around, but David, what are your thoughts on, what are the pros and cons of keeping Celsius in this position? What is the benefit? Why are the UCC deciding to still do this?
I think that what we heard yesterday was, or what we heard last week was, with respect to exclusivity. And what the UCC said is that, they're inclined to, or I don't know if they said inclined, but they understand the position of the debtor, which is that if exclusivity is terminated, there'll be 50,000 plans filed in one day by pro se creditors, and that process is unwieldy. And what they were thinking about was that, if exclusivity is continued, it should be continued, with the committee having the right to file a plan as well. So you jarred my memory to Plan C as to what was being discussed. I don't remember hearing that discussion about a standalone Celsius plan. I might have not been listening at the time. That's number one. And number two, I guess, is what we might have heard today was a little bit of a preview of what's going to happen at the next hearing, because the next hearing, you jarred my memory on this too, is November 15th. Now, it's 2 weeks away, but and it might actually be too short of a time period. But either on November 15th or on December 1st, there's going to be a motion to extend exclusivity. We know that's coming. And I think the judge was sort of giving the debtors a hard time today, and expressing his frustration over some of these issues with pro se creditors and the failure of the debtor to address these issues, as maybe a little bit of a foreshadowing for what might have to happen in order to deal with exclusivity.
Yeah, we have Bradley that's been waiting for a while. This tain't easy, just saying that. So we have Bradley, and then after Bradley, we've got loans, and then we've got someone who was a pro se after loans, which was Johan. He was one of the pro se guys speaking today.
Well, I'm going to help you out, Mary, because my question has been answered. So I'm just going to step down. You can move on.
Thank you, Bradley. I appreciate you.
Yeah, I'll go after Johan. He's a fellow borrower and he crushed it today, so he has the stage.
Okay, this is Johan. Can you hear me?
Hi, Johan. How are you?
Yeah, all good, thanks. Now, I just wanted to sort of comment a little bit on how this whole thing is moving. And when you talk about the UCC, to me it seems you're talking about White and Case or whatever that law firm is called. And when we talk about Celsius, we actually talk about Kirkland. Now, these people have completely different incentives than we have, and probably also not exactly the same alignment as their clients. So I'm a little bit worried about that whole setup, and I find it a bit, I don't know, ridiculous might not be the right word, but it seems like you never talk to the real person here. You always talk to a representative that are incentivized completely different. So I certainly think that the only way forward here is to push for an immediate establishment of ownership status of all assets, and then push for that sale, and somehow establish some connections straight to the entities rather than only through the lawyers. I don't know what other people think about that.
Yeah, to me, this whole ownership thing is driving me absolutely nuts. It's so we have all the information, like Celsius have released exactly how they treat things. We know everything we need to know. Jesus Christ, just put someone that understands how a stable coin works and how custody works and how earn works, that actually has some industry expertise, and put them in the court. Like, just get, like, it's so freaking obvious what to do now. Just rule on this thing. It's driving me nuts.
Yes, I agree, and that there's many issues to deal with in conjunction with that. Now, are we going to throw out the terms of condition because they were changed and they were not correctly changed, fraudulent because they were not pointed out the material changes, and the official communication were always different to the terms?
I think that's irrelevant. Earn was earn, whether it was stables or whether it was.
Yeah, but I'm looking at this from all perspectives. Now, if you look at going into an earn account, what is that? Now, then it doesn't really matter how they change the terms and condition if they continuously have oral I missed the word here, but communication, not written communication, stating something else. And the same goes for collateral, and the same goes for custody, or whatever you want to call the account. And I also think that how then the company has treated the assets does not really impair the promise they have made to whoever opened an account under pretense of opening in some ways. That is then a criminal behavior on the company side, and the promise that has sort of to be made is how you determine the standard or the ownership status of the asset. I'm not a lawyer, that's just how I see it.
Can I give you a very strong example of exactly what you're saying, Johan? So here's an example, and this infuriated me when I was listening to the hearing today. The judge, they were talking about the terms of service, and they were talking about, the earn account and what you signed up for. And the person was just speaking for themselves. They didn't have a lawyer, and they're basically trying to say, like, I didn't understand the risks that I was taking as an unaccredited investor. And the judge says, well, but the terms of service say they're allowed to rehypothecate, do all this stuff. And but just let me quickly finish. But then so that infuriated me because Alex Mashinsky said literally months, like 2 months before the freeze, he said on CNBC that Celsius takes no directional risk. He stated that with no disclaimer on the screen. He stated that definitively on national TV. The terms of service were modified. Customers did not understand the risks they were taking. If they did, they would not deposit the money. So it infuriated me for the judge to say that, because fuck the terms of service. The customers were misled, investors were misled. Now, I don't know how this productively helps us get out of Chapter 11, but it's still, like, there's a part of me that's like, I want to see, obviously I want to see the best recovery for everyone involved because we were all misled. But it's like, there also needs to be justice served, at the same time. So like, I literally will give up some of my recovery if justice is served. And I know I'm not the only person that feels this way. I mean, we all want our money back, but I've seen people post on Twitter saying, I'll give up some of my recovery. I hope the UCC is listening to this. We do not want this to turn into be a Ponzi. That's bad for everyone, but justice needs to be served. The UCC's job is to hold these insiders accountable for their actions. They cannot get away with what they've done here.
But the way I believe to look at this is to look at the kind of interaction somebody have had with Celsius platform. That will determine the risk profile that you went into the platform, and that also validates the terms and condition at the time. I certainly think that we should all be grown-ups, and the first time you sign up, you will sign an agreement for something. Now, you should have that personal responsibility to read that. However, if that is changed in a way that is not legally pointing out material changes, and you have a continuous verbal transmission of terms that is incorrect, which Mashinsky did all the time. I mean, not only on national TV, but on all the AMAs. That invalidates all the sort of future changes. So you have to look back at the sort of original statement and the original style of account, if it's a collateral or if it's an earn account or however you interacted. And from that, you need to determine the property rights of the particular assets. And once you do that, I think it's crystal clear. And then, as Simon has discussed, of getting assets into a fund, and you can try to do a individualized split on equity and coins depending on the risk of the asset that you actually had on the platform. I'm sure that would satisfy most people, because there will always be people able to take more risk and therefore more equity and leave coins for others. So in my view, the road forward is straight and very clear, but I think it's just that nobody wants to take the decisions or move it in that direction.
I agree with you, Johan. Definitely. I think the Kwame, I think that was her name. She brought up the title of ownership of funds, and I think it's very important to determine that. That the judge, Glenn, that the debtor had to provide a detailed transaction history for each creditor, and I think that was the four was Barstow, Holcomb, and Saker. I can't remember the fourth one, but the debtor had to provide a detailed transaction creditor. He wanted to see what the transaction had, and he upped the withdrawals. And what were the terms of use that were applicable at that time? So I think that's very important for us to figure out what were the terms of use at the time that, or when was it changed? So that's going to really tell a story for us.
Yeah, I mean, I thought that was very interesting too, that when the judge asked the question about if this person signed up in 2020, what you know, how do you say that that person is governed anything other than by the terms of use that were in effect in 2020? I mean, he posed that question and the answer was by Kirkland, well, you agreed that the terms of use could change. I don't think the judge was very satisfied with that answer. Yeah, no, that's going to be one of the key legal issues is, you know, whether everyone who was at Celsius is governed by the terms of service when they signed up, or, you know, the terms of service as of April 14th.
Yeah, one good thing that came out was I don't know who did it, but someone made a suggestion that, hey, just put all these things together, because my fear is you're gonna rule on them and then there's going to be another ruling and there's going to be another. So and I think they kind of realized, oh yeah, stables is something and custody is something and earn is something. So that's a good thing. But I think someone needs to make sure that these people actually understand the products, because I felt like I was just listening to a bunch of people that really don't understand the different dimensions. You know, all of us know that you've got collateral, you've got liquidated loans, you've got stables, you've got suspended accounts, you've got withhold, you've got earn, you've got custody, and all of those should be considered together as one thing. You can't just have a ruling on one and then end up with 7 different rulings on all of these different things. So if someone could take that and file a motion of, hey, I'm not convinced that anyone in that room really actually understood that these separate things are just that they're obvious. We understand how the product works, and if you're ruling on one, just rule on all of them all at the same time and just be done.
Agreed. Ronan, and then Chris, and then GL.
Yeah, it makes sense with Manny and Johan up here. Johan was the one that made that comment, Simon, about taking a holistic view. But I mean, I think David might have mentioned it, but this was truly like the revolt of the pro se creditors. And I think that they are filling a vacuum that I don't know where that vacuum in either decisiveness or leadership is coming from. But I just want to give them credit, Johan, Manny. We had our Victor from Spain, and then also Cam Cruz. It's shocking the way like we've dealt with this piecemeal stuff, and just understanding like the debtor in Kirkland. The thing that was so frustrating, we spent the first 30 plus minutes in this hearing dealing with whether we were going to unseal the employee names and their salaries, and the debtor saying, you know, there's, you know, their company, valuable employees. And it's just like, this is not national security, where it's not a national security memo where we're blacking out a whole bunch of information. In this case, every single customer's name has been released. Every single amount of holdings they have has been made public information. We have down to the 10th of the hour what White and Case employees do with our money. We have down to the 10th of the hour what Kirkland and Ellis employees do with our money, with what all the consultants, what they're doing, what they're getting paid. And you mean to tell me that the debtor and their employees not knowing their names and how much they're making with our funds, it is mind-boggling to me. And this hearing was a mess, and I would love what Johan said, to take a holistic view. They're going to rule on custody and withhold. I would love for a ruling to be made on collateral, and I would love for a ruling to be made on earn from Judge Glenn, so we have legal clarity, so that we can decide, hey, if we have legal clarity on collateral, that makes it easy, and that is going to make bidders want to bid on the loan book, and that will infuse more capital into the debtor's estate. If it's not, then we all get together. Simon, hopefully if it's your plan, I would have loved to have seen, it would have been amazing if you had made it onto the UCC. You would have been able to provide master classes to a whole bunch of bankruptcy attorneys on crypto. Unfortunately, that wasn't the case, but if these legal rulings, the judge rules, hey, everything is, you know, everyone is equal, then fine. We go to Simon, to your plan, and we go forward with that. But thank you.
All right, thanks for that, Ronan. Chris, GL, then Manny.
Hey, I just wanted to address something I heard Plan C say, and that is, since the UCC is here, I'm not willing to give up more of my claims just to see justice served. I believe justice is cosmic beyond courts and everything, and it'll be served. But giving up more of what they already took from us is the exact opposite of justice. It's a further injustice. So that is not the solution, and I don't want that to just left stand that I'm willing to give up more of my claim or of my crypto to seek some vengeance. And not that vengeance isn't necessarily due, but it's not a good thing.
Just quickly, I just wanted to just make sure my point was clear. I'm not saying that I 100%. So all I'm saying is there are individuals within the creditor body, not all, 100%. Like, it's good to voice your opinion, because obviously a lot of people feel the way you feel. I'm just stating that I have seen people say that they would be willing to give up a very small percentage. Vengeance is, it's not about vengeance, it's about justice. Like, you can't, anyways, everyone has their own opinion on this, but I would just say is that obviously I don't want to give up a lot of my claim, and I don't want other people to lose more money. And I do agree with you on karma. I'm talking about a very small percentage, but that's really not the main point of this conversation.
I'm not willing to give up another very small percentage to take care of these same people that took a large percentage from us already. That's
trust me, you can both have what you want. Get out.
I do.
Make it an asset of the fund, and you'll both get what you want.
Yeah, Chris, there is the possibility that like money is actually recovered for the fund. So I think it's not like 100% to say that by transparency and the awareness of the facts coming out, that might actually benefit creditors. Like it's hard for us to know if it would be a net negative as far as like financially for us or a net positive. I don't think we want to make those assumptions. And I'm just saying there is a percentage of the creditor body that does not want to see people get away with things. And potentially, we might get more money recovered. So, but I do agree with your sentiment as well. I'm sorry, I'm being emotional, and I don't want to see people lose more hard-earned money. 100% agree with you there. But it's a tough balance.
You can say you want justice, but you don't have to say, hey, we're willing to give up more. I mean, you can get both.
I agree. Okay? I agree. Yeah, I agree with you there. Sorry, I probably said it in a really bad way. Thanks.
Hey, Chris, did you want to add anything else?
No, that's all.
Thank you, Chris. Really appreciate you. Next we have GL, then Manny, and then Johan.
Hi, I guess maybe this question could be answered by David Adler. Is there a legal mechanism or a sort of tool that can be used to sort of say like, whoa, it seems like these legal entities, whether it be the judge, Whiten case, and or even Kirkland Ellis, can't demonstrate that they truly understand the differences between these assets, almost sort of like a referee saying, hey, y'all are speaking a language, but you don't understand the nuance of like a Yiddish word or something like that. Like, it's almost like they're misspeaking about something they think they understand. Is there some sort of legal process to like intercede with some sort of curiosity about that?
I think the legal process in the United States is an adversarial process. So you need to have someone on the other side of the equation say, collateral is not property of the estate, okay? And then the debtors and the committee, if they so choose, can argue against it. But, oftentimes what happens is that, judges will, if they see the case going in the wrong direction, sort of make their opinions known about things, about where the case is headed. But generally, with judges who don't do that, I don't really know what the process is. I mean, what you're describing is, is an adversarial process. If you have someone who's willing to come in and say, guys, you don't understand what crypto is, that person is probably just as equally capable of filing a complaint saying that earn a crypto is not part of the bankruptcy estate. I mean, am I missing something?
Okay, so let me ask you this question. This is a little different. Do you feel the depositors have anyone who's our legal advocate? And you don't need to say Whiten case. We understand in an ideology what they are to do. But since no one really feels our feelings or property or concerns are truly being represented. And there's all these ad hocs which exist, but there is no ad hoc for the largest group of creditors. Do you agree to that? I know you're on the other side, but
yeah, there
you see
is
my
no
point?
ad hoc. I mean, there is no lawyer, to my knowledge, representing the ad hoc group of own people. That's correct.
And is that one of the biggest failures you could sort of identify right now?
Yes,
if you had to
yes.
say?
Yes.
So if you had to throw a dart on a wall to sort of acknowledge who could be the smartest brains who understands legal crypto law, would you even know the answer for that question?
It's not brains. You can find loads of people like that. It's money. Someone's got to pay for it. That's it.
Right.
But who would that legal resource be who could
There's loads of
argue
law
our
firms that
point?
are amazing at crypto, but there's it's just coordination and payment. And so, you know, someone paid David's bill, and that was coordinated and didn't do that.
Right. I mean,
But is there a firm that you would suggest outside of White and Case who could do a better job? And if so, who would that be?
I don't have a recommendation. I mean, I don't know who's involved. I mean, you can look at like a list of there's a publication called Chambers, and Chambers lists the top bankruptcy law firms. You know, from
But it's got to be
bands.
bankruptcy who understands crypto, though, is really what the point seems to be.
Well,
That's missing in all of this.
You know, but I think that the person, I mean, I think that it's more the bankruptcy part, because you start off with the proposition of what is and what is not property of the estate, right? That's the question that Judge Glenn has to answer. And then you have to take the properties of crypto and put it within the definitions of property of the estate or not property of the estate. So, you know, crypto is good. You know, an understanding of crypto is necessary, but I think sort of an understanding of bankruptcy law is probably more important in some ways than understanding crypto, or maybe in some ways equal. Because if the person doesn't understand crypto, I guess there could be other problems in understanding how the blockchain works. But I think bankruptcy is first, and crypto is, you know, second, but probably not that far behind.
That's not the big problem. For solve who's going to pay for it, and I've paid every lawyer. I know who's good. I'll tell you exactly who it is. But all you need to do is find the coordination and funding.
Okay, I'll leave it there, but it just seems like is the obvious thing in this room that the largest, most knowledgeable group is the least represented in all this. And that seems to be what I'm learning about each day, each court case.
My take is that the two largest groups, there's a lot of stuff going on right now in the case that is tangential, okay? And the two largest groups are collateral and earn, okay? And we had a 3-hour hearing, and virtually nothing came up about either group, okay? Nothing really came up about the sale, okay, today as well. I mean, we're talking about key employee retention plans. We're talking about the scope of the examiner motion. Then we have all these separate motions on stablecoin, which is, I guess, a subset of earn. Well, I know it could be a subset of withhold too. And I mean, it's just not dealing with the main issues that have to be addressed to get this company out of bankruptcy. Let's put it that way. And I think that's some level of a sense of frustration, you know, in terms of getting this case out. And I think that whatever the schedule was that was agreed to on the bidding process is probably going to have to be moved a little bit, because clearly these issues, these fundamental issues of who owns the crypto, whether it be collateral, whether it be earned, whether it be custody, I mean, it's going to take longer than expected. And I would not be surprised if this gets pushed out. And obviously the examiner looking into Ponzi allegations, obviously there's probably not going to be, you know, the best bidding for the company while that, you know, while that's hanging out there. You know, people don't want to buy assets that, you know, have the label of Ponzi, or even by retail customers if they think the customer base is going to be subject to potential clawbacks. I mean, I'll say it again. When you say the word Ponzi, we're not talking about 90-day lookbacks. Okay, we're talking about look backs to the beginning of the company. Okay, Madoff is 14 years old in December, and it's still going on. Okay, there was a ruling 2 weeks ago by the Second Circuit that revived about, I don't know, 150 different Madoff cases. And I mean, the best solution is to get this company to a buyer and sold off as quickly as possible. You know, the best solution is to try and create, you know, what appears to be a cohesive and unified customer base so that the buyer is aware of the value of the customer base. And when you say the word Ponzi, and when you start talking about all this stuff, you know, the whole sale process starts losing value, you know, and I don't want to see a Voyager type situation here. And clearly when you start using the word Ponzi indiscriminately, people get worried about that.
100% agree. Great points, GL, and concerns for sure. Thanks everybody for being so patient. Next we have Annie, then Johan, then Eric.
Hey, yeah, so I agree with what a lot of people have said today. I have some concerns with, I mean, on the one hand, the judge seemed very open to the pro se stuff in the sense that there's a void. But then he also seems to want to resolve some key issues without, in my opinion, a totally full and clear understanding of the issues, at least from some of the questions he was asking the pro se people. But, you know, I will say, like, actually, if anyone has good lawyer recommendations, and I'll follow up with you, Simon, it actually has been hard to find a lawyer for EARN, partly because there's so many conflicts, and partly because it's a big project. So they actually are like, oh, fighting for EARN is like, you know, it's like hundreds of thousands of dollars at least, and it's like a big project. I do think we could fundraise actually. If you're a whale in particular, DM me. I already have a big list and I have a big Telegram group, and you should join it if you're not in it already. The Celsius EARN Telegram group. You know, I think our time's probably running out with this December 5th and 6th thing the judge wants to do. So if we want to try to make some arguments before then, we probably don't have a lot of time. I will say that the judge seems, and you know, David, I'm sure you'll back this up, but the judge seems inclined with a typical plain vanilla EARN account to not look at the fraud and misrepresentation. I mean, he's hinted in court as much as someone can, in my opinion. However, he does seem open to some other claims around contract issues when people signed contracts, which is kind of a nightmare. And when he brought that up today, I was like, huh, and I was kind of stumped because I was like, this could be litigated forever and be a nightmare. And it's sort of my position that the group should get together, mediate these things, and come to some kind of resolution. And I'm not actually sure that these rulings are going to be particularly productive. And I'm not yet sure what kind of process they're going to have to look at all of these subsets of EARN, or how much they're going to want to look at all these subsets of EARN. I mean, the judge clearly today was learning about some of the subsets of EARN, like people who had pre-petition contract violations and such, and digging into it. But it's like, to what end? Like, I don't know how this gets us out of chapter 11, right? Like,
hey, Manny, here's something for you to think about. We've always thought about this case in terms of EARN versus collateral versus custody, right? What the judge was suggesting today is maybe those distinctions don't matter. Maybe you look at it in terms of people who were under terms of use 3 versus terms of use 5 versus terms of use 7, right? So that, you know, there's an issue for you that might be relevant, because if the terms of use 3 are materially different than the terms of use 5, you know, both custody and EARN sort of join together on those issues.
Right. But it's like, okay.
Honestly, this is what we tried to warn about so early, that like just accept that if we're going to argue over scarcity, we're gonna be in prison style level, and we're all going to get worse results.
Exactly.
Like
Yeah,
we tried so early on this one, and everyone just continued. I think there's too many people, it's inevitable.
So it's kind of heartbreaking because we started with custody and withhold. And I know some of them are here, but like they did kind of start it. You all started it.
Yeah.
But
I just hope everyone understands that if we engineer this right, you know, I don't give it, you know, I don't care about if it's engineered right and we have, you know, a fund with all the assets, then I'll give everyone my coins that needs those coins, and there'll be loads of other people that will follow. And like that's just yeah. But no, I don't the bit that really scares me is I just really don't think that the people that are in the core really understand these different types of accounts. And then I don't think they have a comprehensive understanding of how Celsius works.
I agree. And like I had said to David Adler, I'd actually said at one point, it would be good to show the judge the app, but unfortunately it's frozen, so it's kind of hard to make a video of it.
Right.
But like he doesn't even get how coins move between, say, earn and custody, for example. Ray, you have to like put it into a briefing. But I also think we're just distracted. I mean, to your point, Simon, yeah, you could start an ad hoc based on which TOS someone signed, but like to what end? And then what if it's commingled and they agreed to multiple TOS because they have different transactions? It's all a waste of time, but like so is what's happening on December 5th and 6th kind of a waste of time, but it's kind of not of a waste of time if he rules one way on earn and another way. I mean, here's the problem, because we all are fighting each other. We're incentivized as earn to fight because it's like if ours is ruled property of the estate, but then say loan collateral is not, well, then that's the problem. So then we all are like, oh, should we get a lawyer and try to make our case that it's not property of the estate? So it's kind of like, I don't know, like, anyway, that's the problem. Or like if custody and withhold hadn't tried to get their coins, I don't know if anyone would be worrying about what's property of the estate.
I mean, right. I think what the judge was saying today, I mean, it's a real valid point. I think this came up in connection with Barstow. But let's suppose that Barstow opened up the account in 2020, March 2020, at the start of COVID, bought 3 Bitcoins, and then never, ever did any other transactions, right? And she'd log on every once in a while, and it would say, by, logging on, you consent to our terms of use. Yeah, you hit the button. Yeah, sure, I want to see what collateral or what crypto I put in the platform. But did she really consent to the terms of use when all she was doing was looking at her holdings of crypto, after March of 2020, which is why I think the judge was talking about sort of a transaction history of, each of these individual pro se claimants to get an understanding. Well, if you went on in 2021 and, you transferred something from Bitcoin to Ether, well, and you hit the box that you accepted it, and then you did something, there's more force and effect that the terms of use are binding on you than if the only thing you were doing was going on there to check and see what was going on.
Yeah, that's fair. It's just, again, I asked to what end, like.
Okay. No, I hear you. I hear you.
Although, hey, the judge also sets a message for those active users that I'll give people as a tip. If you really want your coins back, he seems to be taking these individual actions pretty seriously. So It's kind of open season. I'm probably going to file for mine. I have a pretty good case. So, that's kind of sad. There's plenty of coins for those who are willing to do their own individual pro se case. And I'm guessing they may fare better than the ones who are part of the pot. It makes me very, very sad, I have to say.
It's one thing Simon always references is the prisoner's dilemma. Right? Every time I'm on one of these spaces, Simon talks about the prisoner's dilemma. And that's sort of what the situation that's going on right now, what you just mentioned, is that, there could clearly be a race to the courthouse to file complaints saying this crypto is not property of the estate, this crypto is not property of the estate, no, this group of crypto is not property of the estate. But, part of that is just there has to be some structure. And obviously, these fundamental questions need to be answered prior to a sale going forward. It's 3:20 right now. I have to step off for about 15-20 minutes, but I'll try and come back up until 4 o'clock if that's okay with people. Yeah. Shouldn't take me too long.
Yeah, thanks a lot, David. I appreciate you.
Okay, thank you.
Anyway, look, I'll pass it off to others next, but if people really want to start a collaborative committee with a lawyer for EARN, you feel like having a lawyer would help us negotiate with loans, or that there's something we should try around December 5th. Okay, great. We could probably raise the funds. There's sort of a question as to whether it'll be worth it or what we'll get out of it. I will say it's kind of now or never, because once they rule that it's property of the estate, let's say, then it's probably open season on the EARN assets. That said, how much do we really want to divide the community even further? Like, to Adler's point, if we're talking about which version of TOS people signed, or in my case, I have a very good case for returned loan collateral based on clear contract terms. That's a pure contract case. And so what if we started such a committee and found some people could make good claims and others couldn't? It seems kind of sad to me, right? Like, and to the whole prisoner's dilemma point. So that's kind of where I'm feeling like things are at in terms of EARN. That probably the people who are just pure EARN, like we used to have the pure custody, I feel like the pure EARN have the hardest time. And people with sort of special claims of various sorts have a slightly easier time, at least with this court and this judge. For better or worse, it's problematic. But anyway, I'll stop talking.
Manny, and you can receive DMs for anyone that's interested in.
I should be able to receive DMs unless someone says they're having problems. Please say so if you are. But yeah, if you're interested in either starting a committee, or you just need the link to the Celsius EARN Telegram group, or have any questions, just DM me.
Awesome. Thanks so much, man. Appreciate it. One of the things that was encouraging that, I picked up on is that Judge Glenn said that he wanted to rule on evidence and not on assertions. So that's always encouraging, of course. Thank you, everybody, for waiting. So, Clancy, you have your hand up. You're the host, so you can just speak when you want to. But I've got
no, it's fine. Go in order. I have a question. I have a kind of a comment, but go in order. I'll just keep my hand up like everyone else.
Awesome. Okay, then the order is Johan, Victor, and then Daylong.
All right. Can you hear me, guys?
Yes, we can.
Yeah. Okay. So just a few comments on what's been said the last year. First of all, I certainly think that everybody needs to think about Simon's plan as a concept. So we don't have to be so focused on scarcity. So once we try to get that, wrap our heads around that it's not necessarily detrimental to receive that fund. It's actually probably the best thing you can do. I think we just changed the game board straight away. So that's one thing. Having said that, there are certain aspects of different assets that needs to be carefully considered as not to reduce the value. Here we look at the loan book, because if you exchange one collateral for a different kind of collateral, it may increase the risk profile of that loan book and therefore reduce the value. So those things needs to be considered, but still, I think we need to look at the equity as the really valuable asset here. Even me being mostly a Bitcoin maxi guy, I can still see that with the asset profile of that fund, it could actually go up faster than what Bitcoin would do, and then you could actually exchange for more Bitcoin in a few years, or a few months if we're lucky. But so that's one thing. The second thing, I do think that one of the biggest problems here is that the lawyer firms are incentivized differently than we are. And that is why we have no real rulings yet, because if they were incentivized the same way as we were, we would have ruled on these issues already. It would have sort of basically been done in the first month, because it's a foundation of moving forward. But it's just mucking around with, I don't want to use the term, but irrelevant stuff. So somehow I think we need to establish a way to communicate directly with the, to have at least a secondary way of communicating directly with the entities and not with the professionals that is the go-betweens, because of and I mean, it's just the way I'm not saying that they are bad people or anything. I'm just saying that the incentive structures as such that it virtually inhibits them to push the same agenda that we want to have pushed.
Yes, thank you for that, Johan. Sorry, I was replying to someone. I think we have next is actually Eric. You came back up on stage.
Yeah, thanks for having me. I guess I'll opine on a few things. Today some of the international users. First of all, I have both an earn and in custody, so I just want to disclose that primarily in custody. Some of the international users made comments as that they were at a disadvantage because they didn't have the ability to put their crypto in custody. And the truth is that international users were at a competitive advantage before the bankruptcy. I wish I was an international user and I could have just withdrawn my funds from the platform instead of it going through custody. So maybe some don't realize there's no accreditation status necessary for international users where there is accreditation status for U.S. citizens. So those international users were able to benefit from earning interest on their crypto up until bankruptcy, and then of course they wanted their funds in custody because they feel like it's a more advantageous position, and now they're looking at it like they were in a advantageous position. So it's kind of like one-sided and not really that strong of an argument, and it's bullshit, quite frankly. The other thing that I think David brought up, which I'm a little confused about, was that he picked that he thinks the judge may have a position on different terms of service 1, 2, 3, maybe based on when you joined Celsius. I'm not really sure. The judge obviously didn't go that in depth into it. However, I believe someone in the courtroom today stated it, and I'll state it. Every time that they did a change of terms of service, we as the customers on the platform agreed to those terms of services in-app. So they didn't just blindly change the terms of service without people knowing that they were changing the terms of service. And if people didn't read those terms of service, well then tisk on them, shame on them for not reading that. So the terms of service that the judge is going to look at is April. I mean, I think he made it kind of clear today when he was talking, I believe, with that Vietnamese woman, and forgive me for calling, I based on her name, who made a really good argument that she had multiple accounts and they froze her accounts. And therefore, basically, it says if they dropped her from the platform and they dropped her from the platform before bankruptcy and she had no way to get her funds off the platform because they froze her account. And I think that she had a really good argument there. I know that there's some jokes in the community that maybe she was a scammer and had multiple accounts and she was using the referral program to get additional crypto. She came into our custody Telegram room and admitted that she had multiple accounts, said that those accounts were set up because of different relatives she had, and that each account used a different KYC. So I give her a lot of credit for that, right? I mean, there was nothing wrong with creating multiple accounts if you had KYCs, different people had KYCs for different accounts. I mean, I don't think that was against Celsius's terms of service. At the end of the day, I really don't give a shit, quite frankly. I'm more concerned what Simon said, actually. I hope Simon's still on the stage. Yes, you are. Which is that you believe that everything should be kind of like packaged together. And I don't want to put words in your mouth, like custody, or like, I guess all the outstanding issues should kind of be, the judge should make a decision based on all those issues. Maybe I'm misinterpreting what you were saying, but once the judge takes a position on terms of service, there are different terms of services between users. Clearly, custody, in my opinion, have a different terms of service than earn. Celsius loans, I'm assuming had a different terms of service as well. I believe what Adler said earlier, which is that the collateral from loans is not property of the state, the same way that I believe that custody is not property of the state. And I believe the judge is going to decide, is going to determine that as well on December 6th and 7th or whenever our custody hearings are. But Simon, I don't want to put words in your mouth if that's what you were stating, but I'm confused why you would take that position when terms of service have us separated.
No, yeah, what I was saying is that suddenly, like today, they were debating stables. And then it was like the judge had an aha moment. Oh, right, stables is important to earn, and that's also important to custody, and that's also important to preference. Oh, and now someone's talking about, collateral never gets any airtime for some reason. And then they were talking about, a suspended account and then a withhold. And I just don't think the judge knows that there's like 8 different statuses and each of them require a ruling. And if we just rule on one,
based on stablecoin. So you're saying stable coin in earn should be decided as the same as stable coin in, let's say, custody, or stable coin that a loan.
No.
Oh, okay.
No, just there's well, now you've even got 15, because now you've
Right,
got
right.
custody plus stable and earn plus stable. So now you've got even more iterations. So you probably got 15 different account statuses. And I don't think anyone in that courtroom knows that. If you had those lists of 15 different accounts in a matrix, then you could just say, all right, well, this is, what are the numbers, how much sits in each one, and how do we rule on each one, and what are the key issues with each one? Okay, one feels like they were misrepresented. Well, everyone feels like they were misrepresented. One feels like they had very solid custody terms and conditions. That's different. But I just think if you put me in a room with like a bunch of lawyers, so like, you know, for example, when you had like Craig Wright cases and stuff, you put Andreas Antonopoulos on the stage, he explains these concepts that no one gets as an industry expert, and then the lawyers kind of translate what he's saying into their world. We're not seeing any of that. We're just seeing a bunch of people that have zero clue about the substance behind these things. And so but you know what? To be honest, Eric, I'm just at the stage where I'm at peace with whatever happens. I don't think there's a way of stopping people. I gave it my best shot, saying whatever happens, there's a good outcome. There's a potential good outcome. But I don't think you can persuade 300 to 600,000 people by releasing a few YouTube videos of that. So whatever happens, I don't care if someone ends up with my Bitcoin and I end up with the whole of the fund. As long as I don't get sold as a cash bid, then I'm okay with whatever the outcome is. And I don't think I can influence the process anymore, other than helping other people understand that if you don't get your way, don't worry too much. There's probably like a nice outcome if we can win the bid. And so, you know, don't be too upset if you don't get your way is kind of my message. But it is inevitable. It's the court. We've all spoken as groups. We know the issues, and I think hopefully people are comfortable whatever the outcome is, and now let's just leave the court to do their thing. But hopefully they understand, and we don't end up with 15 different rulings that then delay a bid, and then we end up in a Ponzi scheme claim with an examiner going really deep into things because we're trying to figure out what the difference between custody of a sell token that was put in the wrong account, that was misrepresented, and suddenly that, screw this, like, if the whole thing's a Ponzi or something.
Yeah, well, let me just state, I agree with you on most of the points you just made. I think, and correct me if I'm wrong, I think that you said that stablecoin and earn should be treated just like all other assets in earn. And if that's what you said, I agree with that also, because earn was earning, stablecoins and earn were earning the most amount based on a percentage of compared to all the other assets. So they were earning interest. Whereas I think stablecoin that was used for a loan, or stablecoin that is used, and I don't own any stablecoin, so I don't have a dog in the fight, but stablecoin that's also in custody should be treated differently than stablecoin that's an earn.
Yeah.
That's
I wasn't going that granular. I was just saying there's 15 different statuses. And from my perspective, like I put it out there, I think we all took risk and we were all misrepresented. But everyone feels slightly different.
Yeah, I agree. And I'll get off the stage, but I do want to say one other thing I thought was pretty poignant, which was the judge made a comment about all those videos that were deleted are like coming back to court. So I think that if anyone's looking for Alex to potentially go to jail or whatever, beyond probably tax, which is probably where they're going to get him, it's always not paying taxes. I think that whatever videos that they deleted are probably going to be the quote unquote I don't want to say death sentence, but you guys know what I'm saying. I think that the judge wants to see those videos for a reason, and he's not obviously ruling on criminal in this courtroom, but there is a reason that those videos were hidden. And I thought that was pretty. I felt a little tongue in cheek and funny that the judge said we're going to get those videos back in court if possible. But I'll just leave it at that. So.
Yeah, thanks so much, Eric. Really appreciate your questions. I just wanted to point out that David Adler has returned in the room, so if anybody has any questions directed at him, please do so. Thanks for coming back, David. And here's the order. We've got Victor, Daylong, Johan, and then Plan C.
Okay, hello everyone. I've just got one question or a little point that I want to make. I make a little introduction. It's been said that a lot of creditors on their proof of claims are not only going to include the crypto and different coins they have on Celsius, but that they, in their proof of claims, they are also including fraud damages or the losses they have incurred because of the fraudulent representations or because they have their loans liquidated. So my question is if a lot of people do that or the people with the biggest claims do that, to what extent this affects the buyers or the viability of any plan. Thank you.
Let me take a shot at that because I've been having sort of nightmares about the proof of claim. It started, I guess, probably about a week and a half ago. So when you look at the sample proof of claim that was put on the docket, it spends 2 pages talking about the different types of coin. And then there's, I think, a question 8 that says, state your claim against the debtors. And so for most people, and I mean, you sort of need to talk with counsel on this because every person who participated in Celsius and who was there at the pause, right, has some claim against Celsius, whether it's for breach of contract, for not honoring the terms of service, whether it's for fraudulent misrepresentation, negligent misrepresentation, fraud, pick your choice. I mean, there are a lot of contractual and non-contractual actions that I believe every claim holder has. So I think that the proof of claim would have to say something to the effect of, and everyone should be talking to lawyers about how to phrase it, but you would go through the series of events, and then you would put a dollar amount for the crypto, and then you would list the other types of claims which are clearly unliquidated. You don't know what they are. You would say unliquidated for the remainder. Let's take an example of some people. There's some people out there who have, let's call it, almost unique claims. I spoke to one guy, maybe it's not so unique, but he had a loan, I think it was through Nexo, and he got a margin call on June 10th or something like that, June 11th, and he tried to withdraw crypto from Celsius to shore up his loan with Nexo. Celsius refused to honor his withdrawal request. His loan at Nexo got liquidated, right? So, I mean, he has sort of a unique type of claim. I mean, his loan at another company was liquidated due to the inactions or the failure of Celsius to live up to its obligations under its contract in terms of use. So, I mean, it's examples like that, the liquidated loans people, right? I mean, I can't tell you how many people have reached out to me and told me that, their loans got liquidated. Some of them claim that they never got notice for a margin call, and that, some people did get notice and were given some unreasonably short period of time to cure, and were given time periods to cure, not with crypto to top off the loan, but with actual cold hard cash. Okay, so Celsius said, we don't want your crypto anymore. Send us money. Send us US dollars. I mean, so what I'm saying is that everyone out there has different sets of circumstances. And I think, you have to list those events and say what the claim is, based on those events. And obviously those claims are unliquidated. There's not, they're unliquidated right now. You may assert they're worth $2 million. Celsius may say that's worth $50. But my whole point is to say that the way the proof of claim is structured, it's just really spends pages on the crypto part of it, identifying which crypto you own and in what different, capacities, earn, collateral, custody, and don't forget about the fact that, there are other claims that you have other than the crypto for the failures of Celsius. That's the most important point that I want to say to everyone is that when that proof of claim form is approved, okay, everyone should be
talking to counsel about how to properly fill it out, because if you don't list a claim for breach of fiduciary duty or misrepresentation or something else, there's a very strong possibility that you'll be barred from ever asserting that claim again, unless there's some type of class action that would be brought on behalf of all users and somebody asserts that claim, that class action in a proof of claim. So just be wary. That's my point.
That's really problematic in itself, though, because any claim would dilute because there's not enough. So that's even another shit show, isn't it?
It is, but in the end, right? I mean, what's going to happen? There are people, probably, if we get to a consensual part of this case where the groups are talking, right? I mean, there's going to be trades where one group trades claims against, third parties to another group as part of the plan process. There will be the estate, bringing these claims, or the estate, the liquidator of the estate bringing these claims. But
let me ask you on that, David, because there's let's say you're dealing with a group, and there's 10,000 people in your situation, but you're only dealing with 100 of them. Would you have to get 100% consensus from 10,000 people to force people into such a settlement?
Yes. So I think what would happen, Simon, it's a really good question. It goes back to the plan part of it. I think the reason why you sort of need a plan, even in connection with a sale, is because the creditors themselves need to have the right to elect. So if, for example, 100 borrowers wish to trade their claims against Tether to the Earn Group in exchange for something else, there's a box to be checked off. If other borrowers do not want to trade those claims, right, they opt out or whatever the provision is. But I think, the most important thing for a plan is to give people the optionality of both receiving an immediate distribution of crypto with a haircut, keeping the crypto on the platform and earning out equity. There's all sorts of optionality that I think needs a plan to provide structure to. Does that make sense?
Yep. Thanks for that. Thanks everybody again. I keep saying it, for your patience. We've got some hands up there that have been raised for a long time. So Daylong, Johan, C.
Hi, Manny, this is specifically for you. I assume you're still here listening. I addressed this with David earlier. He gave a really good answer. I'm curious about your answer to it. I don't think you were here yet. We've got Thomas and we've got Scott from the UCC listening now. How do we pressure them in White and Case to say, listen, now's the time, Hail Mary pass, we need to sell this company. Simon's consortium, we're a higher bidder than they are. This needs to be done as soon as possible. What can we do to pressure that outcome to make it happen?
Look, I mean, as I wrote the UCC with a group, and maybe it's not the right configuration. Maybe it should be the ad hoc committees. I don't know if we should be talking with Celsius or we should be talking with the UCC. But I think the creditor groups, represented or unrepresented, are willing to come to the table and talk about trades we can make and deals we can make, so that we don't have to litigate every last thing in court, starting with the December 5th hearing, which is just the latest in a long string of hearings that are going to be coming up if we do it this way. And we'll probably have to have a separate one on loan collateral. The thing's going to drag into New Year. So I think what we need to do is start talking. I had assumed maybe meeting with, say, Celsius, i.e. Chris Ferraro, or quote unquote the debtor, would be a path. I think another path could be just to do it with the UCC, and for the UCC, as Simon had said, to admit that we're not going to get a sale, a reorg through the company. I don't think it helps bids to come in this case. I think we're past that. In fact, I think, as we saw in court today, calls for a trustee may continue, which is somewhat dangerous, but it's also dangerous to stay with the special committee, in my view. So we're in a perilous situation. People don't trust the special committee to do right by creditors. They don't trust them to do their fiduciary responsibility to pick the best bid. I'm glad that the UCC has say in that. I think creditors have a problem with the fact that we don't have transparency into the multiple bids, and that the debtor, quote unquote, with the UCC only advising, at least on paper, would be the ones who come to us with one bid and tell us paternalistically, this is what's best for you, honey, take it. So how about we start talking, we maybe get some limited pool of people who maybe can sign NDAs and see the bids. And how about we, or end exclusivity, or have a deal with the trustee's office to get a CRO who has the powers of a trustee, but do it carefully or something to move this case forward so that we can go through bidding procedures, which we now know are the only path out, and that we get a bid, one that the big groups agree to and make trades with each other, and then we get out of Chapter 11. Like,
well, let me make a
may
I make a suggestion? And you're a very bright man, so I apologize for jumping in. How about you and David ask Thomas and Scott, who are right now, say, hey, we'd like to have a meeting, DM us. And I don't know who represents custody, but that's 2 out of 3 right there.
Yeah, hey, we've already had a great meeting with custody, by the way. Our ad hocs met. People don't even know that. So look, I mean, we're already talking. We just need to start talking with the UCC. And if it turns out that talking with the UCC and taking power away from Celsius is the way to do it, rather than talking to Celsius, then that can be an approach. If it turns out, I'm more skeptical after today that talking with Celsius is gonna really,
Get us up, Thomas, Scott, you're listening right now. Thomas and Scott, please reach out to Manny. Please reach out to David Adler. Please, whoever the custody person is, who Manny is stating in front of the whole world that he's spoken to, get in touch with them. And then your second conversation is with Simon and Anthony Napolitano and Salt and Sean Owen to see what their bid is. And the third step is see if anybody can beat them. And that's it. This is very simple. I don't know why we're doing anything else other than what I just said.
I just want to add that the loans group is scheduled to speak with the committee. I believe it is tomorrow. So,
David, thank you for that.
Okay.
Thank you, sir. David, hey, can we all just recognize
and I'll add to be
what an
clear
amazing
that
job
even
David
though
did.
we're unofficial, we've spoken with the committee too. Like, they did do a nice meeting with us, but it was not at this point in the case. So, things have changed. And sorry, go ahead.
Manny, do you agree that it's Hail Mary time?
Oh yeah. And
Okay.
I think today that became clear in court, watching what happened and the demeanor of Judge Glenn, and also what happened with Ponzi, and that he's looking into different iterations of the contract, and that we're headed in a pretty nightmarish direction if we don't come together as a community and change course quickly. I think it's like prisoner's dilemma on steroids.
I mean, God bless Judge Glenn, but I mean, this is like trying to explain Bitcoin to your grandfather. I mean, I don't know what else to say here.
I just want to say, as a lawyer, today was one of those hearings where that when I've been part of these types of hearings where I'm just praying that it get over as soon as possible. Okay, I mean, because it was, the longer it went on, the worse it went, and these are the types of hearings that you want to see get over with, because it was not going well. And I mean, there was, like I said at the start, I'm very upset with some of the things that took place today regarding the cavalier throwing around of the use of the word Ponzi, the discussions on some of the other topics, which I think, for all creditors out there, whether you're earn or you're borrow, even if you're custody, right, it's not good to have these issues coming up, when you're trying to sell assets of the company. Okay, I mean, people know this stuff, and it hurts the value of the business. And at the same time, I completely understand why the judge was doing it, because he didn't understand why there are these nonstop pro se motions that are coming in, and wants to somehow establish a structure where he can determine, the rights and ownership, or the ownership rights of customers of an earn, and in the different products, although he just kept talking about stablecoin, I was ready to start talking if he mentioned borrow, but he just said he was just focused on stablecoin. But these issues do need to be decided. I mean, there's no other way to say it. They need to be they need to be decided before there's a sale. And you can imagine the frustration. I think the judge said it with Dan Frischberg. I mean, I think what set him off was, Dan was filing motion and then filed an amended motion and then a second amended motion. And each time you file one of these motions, right, the person gets an opposition and then you get a reply. So I think there was, a reply to the first amended motion and then maybe, a reply to the second amended motion. And that's why the judge said, I'm going to hold you to the rules and you have to follow the procedures for motion. You just can't keep amending your motions every time, you think of something new. I think, it causes a lot of confusion within chambers for the court, to keep track of all this stuff. And the fact that, you have these pro se groups out there who are seeking rulings on, topics of law that have never really been ruled on before, pro se, that the judge sort of was saying, I need coordination here and I need there to be a fair fight. So that, and he said it at one point that the people who are bringing these motions understand crypto. They may not understand the law that well, but they understand crypto, and he wants it to be a fair fight, meaning that, there needs to be legal counsel representing these people, making these arguments so that the court can take the facts and fit them within the context of the law.
Again, I'm not nearly as smart on these things or at all as you or Manny are, but I think that this is our only shot at this point without any new information is directly addressing Scott and Thomas and the rest of the UCC and White and Case and saying, hey, it's Hail Mary time. We are literally Princess Leia and you and Manny are Obi-Wan Kenobi at this point. You're our only hope. So please, 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 we will never, ever, ever be more grateful to anybody else, but we need you to do this and we need you to do it as soon as possible. I'm sorry to put that on your shoulders, but I don't see any other way.
Thanks a lot for that, Daylong. Yeah, and in the interest of time, I think that's why he took the, I think it was 4 of the pro se and put them together. So in the interest of time. Okay, so now we have, let's see, Johan, I'm sorry, Johan, Plan C, and then Culpreet.
All right. Hello again. Can you hear me?
Yes, we can.
All right. So this, I would say, is for David. Now, in view of what's just been said, is there not a case for one of the lawyers to make a comprehensive motion to get these rulings going?
For what group?
I would say a comprehensive one. Let's say that a motion to, I've been playing with the thought of doing it myself, but unfortunately I'm not a lawyer. So to get the right weight behind it, to ask for a ruling on all assets' legal status, because I obviously, are mostly concerned with collateral, but it's most as important to get the ruling on all the assets.
Well, it's interesting. I mean, the problem is that, lawyers have duties to their clients, right? And we just can't, tee up something that's, if I'm representing the borrowers, I'm not teeing up something.
Okay, but let me rephrase it then. So if behind the scenes it's possible to discuss it with UCC, and I mean the actual UCC members, not maybe the legal, or maybe all of them together, to get them to file such a motion, because then each lawyer on the other side can represent their own client.
I think that's a very, very good suggestion. I mean, the problem is that I think there, with respect to the UCC, I'm not sure you're going to get the type of direction that's needed for the UCC to do that. And I could be wrong, but I think
you were going to talk to them tomorrow, right?
I am, but I mean, is the UCC gonna go out on a limb and file something, saying that, Earn is not property of the estate? It's not property of the estate?
Yeah, but wouldn't it be possible to just file for the judge make a ruling on that, and then obviously that will need some investigation to be done to find out what the assets are, but just to get that process going, not to file, not to state what you want to have it filed, because they represent all assets.
Well, unfortunately, it seems Kirkland, the debtor, is the one doing it. Now, they may be in chambers or something, may talk to the judge about it. I will say, since we have UCC people on the phone, if they were aware of this and let Kirkland drive it, I find that very disappointing. I understand it's difficult because if nothing's property of the estate, then there's no estate. So it's like, I think the UCC's position, if they were totally unconflicted, would have been the entire time that none of this, or that everything is property of the estate, custody, withhold, loan collateral, and in an adversarial process should have forced each group to fight like hell to have anything determined to be not property of the estate. But that doesn't seem to be the way they've behaved.
No, but the point here is actually it doesn't really matter, because once you have the legalities established, the process can move on, and we can actually get some reasonable
because it matters because if some people's is and some isn't, that's a problem. So what would have been better is
we could get proper negotiations done if we know the status of the assets. Now everybody is talking out of belief that they have a strong case or not.
Right.
But if that is determined, it's much easier to come together and actually decide something good for everyone, because
you're
what leg
correct.
to stand.
Look, I'm not a lawyer, but as David said, unfortunately it's an adversarial process, or we're stuck with something like the Kirkland process, where essentially that to me seems just kind of like I'm not going to quite call it a sham, but it seems like a mini process that's just designed toward a particular outcome, which is maybe fine if Earn's just cool being property of the estate. But at least we have the certainty and can move on. But that's sort of, when you said, oh, why don't we file something to just get a decision? That's basically what Kirkland did for Earn, more or less. And at the end of the hearing, the judge said that I think he is going to expand it beyond stable coins. All he talked about was stable coins.
Yes,
and then I think as a throwaway comment, he was like, oh yeah, I'll extend it out to everything else in Earn.
But this is the problem. You are talking about one asset or one asset class or whatever, but it needs to be brought up as all assets should be determined. And maybe it's appropriate then to say, because of all the fraud, misrepresentation, and TOSs and all kinds of stuff, just treat everything the same. It doesn't really matter. The key is to get that done. It facilitates a bid, and it facilitates negotiations between different asset classes to get this shift moving.
Well, that's something where the UCC could at least take a position. I agree with you, where they could at least say, look, we're not actually done here until we do loan collateral, and we're not actually done here if doing it through the lens of stable coin doesn't really make sense. So let's not obsess with stable coins.
Exactly.
It's not, we shouldn't decide Earn via stable coins, first off. So that's a big problem, because a lot of the other claims that Earn has aren't relevant to stable coins. So
yeah, what I'm trying to say, we're getting pulled into this myopic viewpoint just to keep the process
all the
going.
returned collateral claims by definition aren't stable coins, and all of David's clients aren't stable coins, David Adler's. So it's a poor mechanism to decide. I suppose I can write a letter about it. I think the judge might be a little mad because he wanted to do it, but I will reiterate why it's a bad idea to decide Earn via stable coins. But we need some comprehensive way to decide. So I think I would say, yeah, we do need a way to decide Earn property rights and loan collateral property rights. And yeah, we should probably do it at the same time.
That's what I'm saying. That's why I'm saying that whoever talks to the UCC members, because I think that's the entity that is in the right position to broach a comprehensive approach.
Yeah, I agree, and I'm frustrated that I'm talking about writing a letter to the judge much about this when we have the UCC. So like, you know, hopefully we can see something like that. I'll give it like a couple of days. You know, like, yeah, I think everyone can hopefully agree that these issues have to be decided. David said that, I said it. I may be unhappy with the mechanism by which it's being decided. I don't like custody and withhold being decided through a protracted adversary proceeding that goes on 4 months and he wants to decide in 2 days on earn. I think that's unacceptable. But I think everyone can agree the issues have to be decided.
Yeah, that's what I'm saying. And to try to push UCC to put in a motion saying that let's just decide on all the status of all the different assets and then move on.
Hi, this is David Adler. I do need to sign off now. It's 4 o'clock. But it was great talking to everyone, and I'll speak to you again in the future. Take care, everyone.
Thank you.
Thanks, David. Appreciate you joining. Thanks a lot. Enjoy your day.
And I too have to sign off. I have a call that I postponed from 3, but I can't postpone again. So
Thanks, Manny.
Thank you.
Talk to you all later.
So Plan C, did you still want to go? Because if not, I'm gonna. I had Pantoni on, and then he fell off the stage, and now I got him back.
Yeah, I just want to say a couple of quick things, and yeah, David had to run there. It was part of it was going to be directed at David, but I can ask Simon as well, and just get everyone's thoughts on the stage here. You know, just from listening to the whole hearing today, you know, we had these obviously a lot that's already been discussed on this call. You know, there's a lot of scarcity. You know, naturally people are frustrated, and there's a lot of scarcity kind of assessing all the different buckets and all this stuff, right? But at the end of the day, I mean, my biggest thing at this point is what can we do? How can we make our voices heard to push forward for this necessary steps and process to get us out of Chapter 11? I think from listening to the hearing today, I don't want to speak for everyone, but like, it just seems like 99% of people, if you listen to the whole hearing and you've been following everything to this point, you know, I just don't know how any logical person could think that there's an actual go forward plan with Celsius at this point. You know, we saw it today on the hearing. You know, like basically everyone was agreeing, like, okay, the examiner needs to look into all this stuff that's occurred. The only one opposing it actually was UCC, but we don't know all the reasons they were doing so. But the point was, you know, we had actual state regulators, you know, all saying they really, you know, this needs to happen. So the consensus seems to be that all the stuff that's coming forward and continues to come forward, it's not going to happen with a Celsius go forward plan. It's a pipe dream. I've been saying this now for months. I've literally called out Alex, you know, right at the beginning. I was late to the party, but as soon as the freeze happened, it clicked with me, and I called him out. Everything's kind of coming to fruition on that front. But like productively, right? What can the UCC do? Like, what can we do within this process to get this bid to happen? And how can we get this bid to happen in the most transparent, productive, and fair way so that creditors can have a say in the process? To me, that is the most important thing. We can sit here for hours and talk about the nuance of all the buckets we're in, but we need to have a go-forward plan with someone we trust. It cannot be Celsius. There's literally a very vocal, like fraction of the community that used, like a lot of these people used to literally work for Celsius that are still defending Celsius. 99% of people are on the same page that we need a new entity to come forward, someone in this bidding process, whether Simon or another person that is a trustworthy track record, has the licenses, can get us out of Chapter 11 and can get us away from all this inertia that's occurring that continues to increase. So like, my question is, does that mean we all push for ending of exclusivity with Celsius so we have a transparent bid? Like, what can we actually legally do within this framework? That's what I kind of want everyone on this call to, I don't know, we need to somehow make our voice known. Like, what can we actually do? Because it feels like we're kind of captive here. You know, it seems like we just need this bid to happen in a way that is actually beneficial, that doesn't just go to the interest groups of, you know, the lawyers protecting the debtor from whatever and all this other stuff. I'm rambling, but does anyone have any thoughts on, let's start with Simon. Like, what would you like to see happen, Simon, for you? Because you are going to be a bidder. Like, what would you like to see for yourself and anyone else that's coming forward to improve the likelihood of a go forward reorg? Not a go forward plan with Celsius, but a reorg with someone that's actually credible.
raise a shitload of money so that no one can outspend us. And we're going to be launching a funding round. That's the most proactive thing we could do. The more money we have, the more likely we are to win. If we have hundreds of millions, then I just don't see how anyone else can win.
And okay, for sure. I appreciate you saying that. What else would you like to see as far as like the process?
If we don't raise enough money, we won't win. If we do raise enough money, we will win.
And do you trust that the debtor is going to be able to make an unbiased, fair decision for creditors on who they accept in that bid process? Do you feel
money talks? As long as you have the regulatory to bring the business back online, then even if the process was you just do a cash bid and then a commitment to do things differently, that's it.
So we don't need to end exclusivity in your opinion. We just need to get this bid going, and you basically personally need to raise the capital, and you feel comfortable with everything going.
Yeah, or you need another company that you want to back that can do what you want them to do, and they need to have the money. That's it. I don't think there's anything else to it now.
Right. All right.
Can I go ahead and ask my question?
Go ahead.
To Simon.
Sure.
Yeah, Simon, if Bank to the Future were to be engaged in this process, can you explain to us, or can you just tell us directly? Can you give us an example of one license that Bank to the Future will bring to the table that maybe Celsius doesn't have?
So there's three parts of the business. The Earn program is a security. So you need US securities and non-US securities. That's what we built over the last decade. And then you need, if you want to offer loans, then you need lending licenses. And that's what Salt has. So I think Celsius has 6 state licenses and some of them are being cancelled. And you need every state, and then you need non-US lending licenses as well. And then if you want to offer custody and staking, then you need money transmitters and virtual asset service providers. So those are what we've been building. Or you need a bank, a federal state charter. Celsius doesn't have any of those. They got 6, from public information, they got 6 lending licenses that they applied for it this year. And a money service business registration. So you need to solve securities to offer you need to solve the money transmitters or bank license in order to offer custody, or a trust license will do it as well. And you need to offer US and non-US for all of those to do it on a global scale, and then you need the lending side. So we put together that infrastructure. That's what we've been working on for the last decade.
Got it. So it's safe to assume that you feel confident that Bank to the Future has all the licenses that need in order to be engaged in this process. And
well, it doesn't matter. The regulators will tell us if they disagree, then they'll tell us we can't offer the service.
Got it. Thank you, Simon.
One thing I do know we can do is we can issue coins and we can issue securities. Now, if they say to us, oh, you can't offer the Earn program until you do an S1 filing, and that takes 2 years, then that just means we can't offer that service until that's fixed. But do we have what we need in order to execute issuing securities and giving people their coins back in the US and outside the US? Yes.
Got it. Thank you, Simon.
Thank you for your question. Now we have Kulpreet, and now it's.
Hey, thanks for opening this up for me. I wanted to ask a couple of specific questions, but that conversation has moved on. Now, this was with regards to what was being discussed for the lady Bear Stars, her situation, as well as the person who had who was grandfathered into earn and not into custody. I'm in the same boat. Long-term account holder, not many transactions, but deposits into Celsius, and then eventually, without any option, based on my state's regulations, it was transferred into earn. But I don't want to labor too much on it because the conversation has moved on to the solutions now. So I have one quick question for Simon. Simon, you just mentioned that money talks and you're confident of winning the bid if you have the highest funding available. What about other scenarios wherein you are open to retail clawbacks or insider clawbacks while other bids are not, which gives more, which is more amenable to Celsius and Alex and.
Yeah, so I already covered this. Did you watch my 7-part video series?
I'm sorry, I didn't.
No, definitely check it out. If you're a creditor, honestly, you have to watch it. I created that to address all of the issues, and I know that they're long, but there's 7 videos that are about half an hour.
No, my question is very specific though. I'm asking, are you still confident of winning the bid if others have no?
So if you allow Celsius to run the business and it goes into Chapter 7 or Celsius carries on, then clawbacks will always be there. It's an option for Celsius. If it goes into Chapter 7, it would definitely happen. If it's called a Ponzi, it's guaranteed. If a bidder comes along and buys the business, then you can put in the agreement when they bid for the assets that they won't pursue clawbacks. Simple.
No, I'm sorry. Did I misstate my question? My question is, are you still confident of winning the bid because Celsius team is the one who's actually, deciding on the bids right now? And if you
firstly, I'm unable to confirm whether I'm in the bid or not. But if I were in the bid, then I'm confident that it's just about raising enough money.
Okay.
Did that answer your question, Alfred?
Yeah. I mean, I was just slightly concerned that, if we have clawbacks related items in our bid or possibilities in our bid, while some of the others who are more amenable to Alex and team, even if the funding is low, they might just go ahead with those.
Money talks, just that's all you need to know.
Okay.
Thank you so much for your patience and your question, Culprit. Now we have Alexander and then Stephen Ivan.
Yeah, thanks for bringing me up. I hope you can hear me. And I just want to push back a little bit from what this gentleman Eric said, that he actually kind of feels that European or abroad the US account holders were kind of favored because we could already earn on our assets. Again, why I want to push back on that is because, as also the other speaker said, I never had a chance to divide between different categories, right, or different accounts for custody or even hold and stuff. So there was not this possibility,
but none of us would have chosen it anyway, there because we were all there for the yield.
No, again, I mean, I never had the chance, right? And there was also this option.
Yeah, what I'm saying is, even if you had the chance, you wouldn't have picked it because everyone was there for the yield and everyone was there for the collateral, right?
That's not again. I only had the chance to withdraw funds if I did not. I thought this is coming because in 2020, mid of 2020, right, we had the chance to opt in to secure our coins, whatever that meant. And I actually
it would have meant you give up your yield and you wouldn't have done it.
Yeah, I would have done it because again, I wanted to actually kind of move some assets in real cold storage or custody.
Yeah, but that's not cold storage. Cold storage means self-custody. That's just giving your coins to someone else to look after and earning a yield.
Again, yeah. What you're proposing also with your fund and then having this stored coins in custody is that even if I'm not the private key holder, I could have these assets if you do not lend them out against them. Again, I can only push back that Europeans were privileged or whatever because I was looking for this option to push them actually into custody, and yes, do not earn yield on it. And
I think we can all.
Hold on 1 second. Otherwise, I don't understand this option to insure clients, right? I mean, insurance costs, but.
I think we can just agree, like, there's gonna be a million different unique situations where everyone's gonna have their own opinions on, you know, if they were misled or mistreated more than another group. I think that we should try to keep the conversation as much as possible, solution oriented, because there's just gonna be endless back and forth on people. We're not, at the end of the day, you know, we need to, as a group, focus on what can be done to get us out of Chapter 11, and that's kind of if possible, if we could try to keep the conversation in that direction, mostly would be, I think, most productive, personally speaking.
Lancy, I agree with you. I just don't know, you know, how the GUI or the front end looked for your at your end. I can only tell you that yes, there was only this earn account. You saw all your points. You have the address, which stayed the same. So there were no other chance to deposit, for example, your Bitcoin to this one.
I'm in the same boat as you. Yeah, as an international, I have the exact same situation as you. So I was not able to put it in custody. Same boat as you. I think the bigger issue is more just, yeah, I mean, there's.
Well, I can tell you, if you go to either Sol or Bank to the Future and you deposit funds, you won't receive any yield and it will be held in custody.
Yeah, so there will be, maybe you're able to speak or not able to speak, I'm not sure, Simon, but for international non-accredited, will there be an opportunity to use, to participate in a fund or use an earn-like product with your service, like in the future? Because with Celsius, I mean, international, they were unaccredited, right? Like everyone, it's funny because everyone wants to have all the benefits, everyone wants to use the services until those services burn them, and then they want to say, like, I shouldn't have been able to use that service, right? It's like I'm unaccredited. You know, I was happy to be getting yield once I realized, you know, as an international unaccredited, that I should have been kind of protected from this product. You know, it's just kind of like people want it both ways. But what would you say there's a path forward with the correct licenses for unaccredited international, you know, to be using the server product?
Depends what you want to do. So I created a matrix where I went through all the different services and what you can and can't do in video 4. And I think I tweeted it out recently as well again. But so if you're talking about holding funds in custody, it doesn't matter whether you're accredited or not. If you're talking about receiving shares as a result of a bankruptcy claim, it doesn't matter whether you're unaccredited or not. If you're talking about buying securities, and remember that you've got to get your head around that Earn isn't a deposit. That was an illegal bank. Earn is now a security. So if you want to buy more securities, then you need to qualify. And so if you go to Bank to the Future, if you verify your account and certify your account, it will tell you, you do suitability, you pass a test. If you pass the test, that you know how securities work and you understand the risks, then you have an account, and it unlocks different things. And so there's also, for example, if you can't buy securities on the primary market, you could buy them from somebody else after a 1-year lock-in as a non-accredited US investor. So it's a bit confusing because it's global security source, but there's options for everybody. It just means that there'll be certain services that are not available to you. But everybody, here's one thing that's, with sanctions aside, everybody can receive their coins and they can receive securities as part of this bankruptcy process. Now, whether you can use Earn in the future is based upon the current licenses and then a future roadmap of licenses. But it's not really relevant for getting out of Chapter 11, whether you can use the service going forward.
Yeah, exactly. And that's kind of my point to the previous call, because I totally understand his viewpoint. I'm in the same boat as him. I think everyone just, like I said, individually we would have endless discussions of who was treated better and who wasn't. But I think we just got to focus on how to get out of this and solutions.
All you need is a way of receiving your coins in custody and a way of receiving securities, or just an acceptance that you're going to be sold to the highest bidder and you're just going to receive cash and lock in your haircut. or we're going to end up in Chapter 7 or a Ponzi scheme scenario. And that's the worst outcome for all. Right. So all we need is an approach for how does everyone receive what coins are left in custody. So you own it, you can withdraw it, you can do whatever you want. You're not locked into anything. You're not asked to give up your stake. You're not all told, oh, these ETH are ours, and we're going to keep the stake to fill our hole and cover our operational overhead while we build a plan together. You just need a way of receiving your coins to the left and a way of receiving a security that gives you exposure to everything that was purchased with our money. And if we can achieve that, then that's the mission. What's the mission to get there? Well, we need regulatory approval that we can compliantly do it. And then we also need to show that we've got enough money in order to do it. And that's the process from here if you want to have a Chapter 11. You also need a sponsor, a company that's willing to do it. And that company, unfortunately, couldn't tell you what they're doing because of the process. But if they did tell you what they're doing, they might have released an educational video series to try and support people without releasing a plan, because if they release a plan, they'd be disqualified from the process. And then what they might do is they might get it in a way where you have to vote on it in the end anyway, so it doesn't really matter because you'll get the final decide when it votes. And all you've got to do is avoid a cash bid.
And it's plenty, and Simon, and that's the last what I say to it, right? The only thing why I'm bringing this up is I never had the chance actually to, let's say, deleverage for myself to say I want to have these coins in custody and do not earn anything on it. It was promised, but the only thing, or the only way I could kind of deleverage myself would have been withdrawn the coins from the platform, right? Which, yeah, do the hard rule wallet.
All right, thanks for that, Alexander. Next we have Stephen Ivan and then Cam Cruz.
Okay, thank you so much, Mary, Clancy, Simon. Can you all hear me?
Yes, we can.
Well, Simon, thank you so much. You are super patient, obviously. I just wanted to answer maybe a question that Clancy had asked to Simon. It's very simple, and I'll confess I'm simple. I'm a simple man. I have coins in all the different buckets of Celsius, including the loans and the custody and the earn. And I was a former ambassador for a few years with Celsius as well. It seems to me that everyone, at least on this call today and a few others, we're all kind of more or less thinking the same. We have maybe a slightly 5%, 10% different view on how to reach our goals, which is to get out of Chapter 11 and move this whole process forward. And I've also participated in a few polls that you put out, Simon, and a few other people. And it seems from the polls, it's clearly majority opinion of how the community wants to proceed. Unfortunately, it's a majority of a small part of the overall community. And I didn't listen in on the court hearing today. I'm going to give some assumptions here that we have a judge who's very positive and wants to help the creditors, which is us. And then we have the associates, the depositors or whatever they are, defendants. And they have all these lawyers that are trying to protect their interests that are standing between us and the judge. And then there's a couple of other committees and lawyers that are also representing different groups that are between us and the judge. And I've heard you say on a few podcasts, I believe, Simon, that unfortunately, Celsius Network is the only one that controls the emails to everybody who is a creditor. And it seems to me that everyone feels that a standalone by Celsius is just a lose-lose. We're not going to get anywhere with that. And a standalone by Celsius Network could be their end game, so they get out of this whole process without any legal ramifications or less legal ramifications than going through with a bidder or an open bid, let's say. I'm just putting out these assumptions because I don't know. Is there a way, I know Clancy asked you, what else can we do? Is there a way? Can we make a motion? Can we move the court? Can we get a way to send out a few different options or a series of votes to the entire community of Celsius creditors to vote. And it's not going to be maybe like vote today and it's over, but a series of votes to move us closer to getting the heartbeat and the pulse of the entire body of creditors, how we can move the whole process out of Chapter 11. And then let's say it's a bid or it goes with Simon's company or a higher bidder, like I think someone said Simon's very agreeable. If it's a better deal, you go with that. Whatever's the best bid, we'll go with that. And again, I'm assuming that the judge is kind of favorable towards the creditors. Is there not a way we can move somehow, some way legally to get a couple of, I guess there'll be a legal team involved, you make a draft, we get a couple of options. Does it, first draft, does everybody want to get out of Chapter 11? Yes or no? Boom. Whatever it's going to take to move past this quagmire that we all seem to be in with so many different options in the fire, so many irons in the fire that it's getting a bit, maybe we're kind of getting a little bit weary with what we're doing to try to move us and move the ball to the goal line, which is out of Chapter 11. After that, let the courts take care of all the rest. Anyway, that's my question.
I think we've got a process. It's called a bid. It's called a judge. It's filing, trying to determine who owns what. And then once you're through it, we're done. In order to achieve why do we need to change the process? You need to change bankruptcy law. That's legal reform. That would take you years. The process has been defined. The process is got this far. Now we just need to go through the process. The only thing that's causing confusion is whether people believe that there's going to be a Celsius 2.0 or a Celsius comeback or a Celsius reorg. And those are just, that's causing some confusion. I think, and that's it. And so people are focusing on whether that's going to happen or not.
And how is there a way to I mean, I know we have court dates coming up. Are those by those final dates, they will be opening?
It's already done. It's already announced. It's already announced. Everything happens before Christmas this year.
Wow, happy Christmas. Okay, I'm going to sign off. Thank you.
Yeah, it's all done.
Thank you.
Sorry, sometimes I'm so close to the process that I actually forget that most people don't know all this stuff because they're not bloody reading this insane amount of information every day.
Yes. A lot of information, that's for sure.
Crazy, isn't it?
Yep. And next we have another pro se, Cam Cruz.
This will be my last one, by the way. I've got to go for dinner.
All right. Happy dinner.
Yeah. I guess quickly, I wanted to just talk about, we brought up Earn having taken the advantage of getting yield. I would say for customers such as myself who have only put money into the platform over the course of the last year, never taken anything out, my yield in real market terms today is negative 70%. And I think it's very differently situated from somebody who maybe withdrew 75% of their funds. We eventually get back to a 50% haircut. That person would be north of 80%, whereas somebody in my situation would be still looking at just 50%. So I think there are some concerns there, probably not worth diving in too much there. I wanted to talk more about the revelation that Voyager was a significant client of Celsius, which had been released in a PR release, I think in 2019, but it wasn't clear the exposure that they had. Somebody on Substack had uncovered in Edgar filings that I think as of September of last year, they had 29% of their exposure of deployed assets on Celsius. And I happened to just stumble upon this when I was tracing network transactions on the EOS network. And there was a large 70,000 EOS withdrawal that I traced to Voyager. And then I saw, well, these guys are taking out $5.6 million between May 25th and May 27th, right when things were falling apart. And looking at one of the wallets that were uncovered on the Ethereum network, it also had made a $100 million withdrawal on March 9th. And I mean, this raises a lot of really interesting questions that Judge Glenn didn't want to address today. But I mean, Kirkland is representing both Voyager and Celsius Celsius's pause was on June 12th, and eventually Voyager closed on July 1st, about 3 weeks later. But somehow Voyager is poised to exit their bankruptcy proceedings, notwithstanding all the complications with the Celsius case. It seems advantageous for Voyager, representing both clients here, to get Voyager out first, because otherwise there'd be pretty large preference questions around this $100 million plus of USDC that they withdrew from Celsius. So they'd essentially be escaping before these preference considerations are closed. It kind of calls into question, initially Kirkland was saying, hey, we have separate attorneys representing both cases, even though Sussberg had filed the opening motions for each. There's a lot of, I think, questions around this type of thing. Essentially, Kirkland has ruled that Voyager is not an insider, which was the reason that this withdrawal of $100 million did not appear on the SOFA report. Otherwise, they were an insider, would have gone back an entire year. So they're essentially deciding these things seemingly to the advantage of both clients. And I suppose if we want to maybe share thoughts on that, I'd be interested to hear what the reaction is.
Yes, I'll take that as the last question before I drop off. I think the way I'd leave it is how they managed to get all this signed off with no conflicts is a miracle. Every lawyer I've spoken to, when there's conflicts like that, you've got no chance, and the legal system is set up to avoid scenarios like this. But for some reason, that all happened, and we are where we are. And what I would say is that one of the things that I would think would be really important in the value of equity going forward, if you ended up getting a fund or equity, is that within that agreement, you get entitlement to all these cases that will be settled over the years ahead. And so if there is funds that come back to the estate, it should be held in a trust that's for the benefit of creditors. And then the fund is set up where it can distribute these funds in a way to 300 to 600,000 creditors. That's how I would deal with that one. Because if we take all of these issues, we're going to run out of money and we'll be in Chapter 7 and we'll be called a Ponzi scheme by the end of it, and that's not going to help any of us.
Yep, I guess my last parting words would be, I'm predicting that FTX will come in with a bid for us, just because of how involved they are with Celsius's business. They're also heavily involved with Voyager, and then they swept in for the incremental bid of, I think, an extra 100 million above the value of their assets. It's almost, the way I'm viewing it now, is they're compelled to pay extra, partially because they got out 100% on their loans, kind of receiving preferential consideration, but also it's a way of burying any nefarious activity that they may have engaged in, which an investigator, I'm sure, would have a lot of time to spend on, and hopefully we get out the other side without getting caught up in that.
Yeah, one bit of hope I'd give there is that the leader in the charge of doing, the judge asked for one of the state regulators to kind of take the charge in assessing who's suitable. And it was the Texas state regulator, and the Texas state regulator has filed an investigation against FTX for offering unregistered, unlicensed securities. So at the same time as analyzing whether they're regulatory are suitable to offer securities, they're also being investigated for offering unlicensed securities.
I was just going to quickly add, Simon, if it's determined that FTX, if it's determined they acted in a way that was not kosher during this process, because you have guys like Dirty Bubble, which, the guy's completely, as far as I've seen, he's been basically right about everything he's pretty much put out there. And he's, starting recently, he's been kind of drawing a lot of links between FTX and Celsius around that period, as things were going south. Just a lot of transactional movement between FTX and Celsius. And obviously, with Voyager, it's like, to what degree is there coordination? There's just so many unanswered questions when it comes to FTX's involvement, Voyager's involvement, the link between Celsius and those companies. And if it's determined that FTX was doing things that yeah, we're not in the best interest of users, yeah, I'd like to, in that case, you know, kind of disqualify them from the bid. Like I just, yeah, that's just kind of how I'm seeing it. But you bring up some good points, Ken.
And is all that within the scope of the examiner too? Because Judge Glenn was tasking both the examiner and the UCC to kind of work together and figure that out. Is that within the scope of the examiner?
It's just opening a can of worms. Like, I don't know. What do you think, Simon?
Well, the regulators are going to sign off on whether they think a bid is regulatory appropriate, and that's going to be regulators. And then the examiner is going to produce impartial information in order for everyone to use. So what was basically being said is that the UCC said we did an investigation and we've got all this information that we haven't published yet. And they're saying we didn't want to publish it because we think it would harm creditors if we publish it. And so the judge was saying, yeah, well, you've got an agenda, which is your agenda is to support creditors. And then the examiner was saying, well, we could do it impartially. And so they were saying, why don't you just share all the information that you did, UCC, with us, and we'll publish it impartially. And so the examiner is about just publishing the information so that then the Department of Justice, the regulators, the UCC, anyone can use that information. Creditors that want to pursue lawsuits in the future, whatever it may be. So that's kind of like the different players in the game. And so the UCC, I still want to believe, I know that people like speak badly and they spent a lot of money, but Jesus, man, they've had to do a lot of shit. Like they got rid of the board, the co-founders. They have been doing massive investigations and releasing the information that they think is appropriate while holding back the information that they think is going to harm creditors. They've been, settling, fending off all sorts of stuff. They managed to get the process updated where it doesn't go just to the highest cash bidder. And they managed to adjust the whole thing to accommodate a process like the recovery plan, the recovery ideas that we released out there. They're expensive, but sometimes you got to pay a lot of money for the right service. And I don't know, like I know people are very critical, but they've made a lot of right moves as far as I can see. And if this ends in the right way, then they probably made all the right moves. And then all the information comes out later, and hopefully it can be constructed in a way where everyone benefits financially from and everyone gets their justice or whatever they, with in that way. So yeah, that's I think that's where the process is. What was the question? I don't know if I answered a different question.
I don't think that there was. I think Cam was just bringing up a point about Voyager and what his findings are, and then Plan C was just talking about Michael and what he's found through analysis.
Yeah, but if you look at Greg's face, he was really in the court. He was just saying, "There's so much I know, and there's so much I can say, and there's so much I don't want to say, and there's so much I want to say." But I think he's genuinely trying to get us through this process.
Yeah, maybe that's the biggest thing, is just that the average person, the average creditor, we're looking at this from the outside without having access to all this information, and we're just looking at it, we're frustrated. But at the end of the day, the UCC and the lawyers, like you said, even though they're expensive lawyers, at the end, once the end result, we'll all can look back in retrospect and understand more how it played out. But yeah,
it's that whole thing of everyone's, there's a beauty to this democratized process, but at the same time, not everyone should have a voice. Sometimes, if you ask me to talk about cooking, you really don't want me to have a voice because my opinion just really doesn't matter. If you want me to talk about financial engineering, then you probably want me to have a voice. If you want me to talk about Bitcoin. And the challenge here is that, we're sometimes you just need experts to do their shit, and sometimes you just don't know why they're doing it, but they're actually doing it because they're bloody good at what they do.
Yeah, so as long as we have robust, I can't even speak now, I'm tired. As long as we have robust bidding coming forward over the coming months, then, you know, it seems like that, even though there's a lot going on and you know, the court hearing today seemed a bit chaotic and all over the place, and there's a lot of individual parties, you know, putting forward their cases. As long as we get the bidding coming forward with the right capital, you know, we might, even though things might seem dire, we could end up seeing you know, no promises, but it could end up being a decent outcome here for everyone involved. And we kind of switch from that scarcity to that abundance mindset. So we just need these bids to come forward, the process to play out, no blocks, no delays of this bid process. This is the process, like you've said, Simon. A lot of people kind of waking up to that as well. It's just, can the capital be raised, and can we kind of get the ball over the, whatever the end line or the ball, you know, at the very end of the game here, can we kind of hit the last shot and get this bid process done, is kind of how you're seeing it, I guess.
We want the ball in the end zone, and we want to get the extra point too.
Yeah, just do what Sam's doing. Sam's silent right now, raising finance, telling everyone how they're going to make a shitload of money if they buy Celsius. And that's the process.
Yep. All right, Simon. Well, thank you so much. Enjoy dinner with Bliss. Appreciate your time as always.
Okay, thank you.
All right.
Thanks, everybody.
Thanks, Simon. Appreciate your time. Thanks a lot.
Okay.
Thanks, Mary. Do you want to keep going a little bit if a couple more people had something to say? I'm open to stay if people want to share anything.
I am too. I'm fine with a little bit more time. I've got maybe 10 more minutes. And I know there's been some people that have been waiting, so I feel bad them not having their say. I do have, I guess Munch has been waiting for a while. So if you want to speak, go right ahead.
Yeah, I guess this is my first time speaking, but I just wanted to say, like you said, it was kind of a mess today. And tuning into this here, Twitter Spaces, just had a couple of questions, and I wanted to share information because we don't really get a good summary, and I'm sure other people have the same questions that I do. One being just the timeline of things. It sounds like they're meeting on the 15th, and that's when they're going to talk about the bar date. I heard Adler say that we have to get counsel to create a claim, but I thought that if we were okay with what was on that PDF, that we wouldn't have to create a claim. Is that correct? I mean, obviously not legal counsel, but.
Right. So not legal advice, but if your claim, from what I understand, if your claim was correct, then there wouldn't be anything that you have to do up to this point. And then as far as the timeline goes for what's going on, the UCC has a calendar events that's pretty accurate. So, you know, I would suggest you go there, you know, to see the different dates of what's going on. You know, don't want to misspeak on any dates at all. At the hearing, they were talking about, you know, November 5th and December, I think it was 5th coming up as well. So I encourage you to go onto the UCC to get those specific
Mary,
dates.
can I jump in for a second here to answer that? Okay, I'm not a barred attorney. I do have a JD. Okay, so you cannot take legal advice from me. However, what David Adler was talking were claims that are on top of your money getting back. For example, if your brother-in-law killed himself or something like that, that there's other claims that are going to be made besides just getting your mother back. I'm pretty confident that's what David Adler was talking about. Does that help?
Understood. Thank you. Thank you. Yeah, for sure. And thanks for letting me know about the calendar. I wasn't aware of that, and maybe other people won't as well. So yeah, just with everything going on in today's, you know, meeting or, you know, court hearing, it was kind of just weird of like Simon said, we're going into matrices that we didn't even know existed, right? Like we're talking about, you know, the main different accounts, and then you're talking about different coins in those accounts. But what, you know, different coins are stable coins versus not, etc. It's going to go down a rabbit hole if we don't figure out how to unite, like, you know, we're talking about.
Right,
So.
but just be aware, and please ask an attorney, because I'm not a barred attorney. I do have a JD. I'm not a barred attorney. I'm only going on stuff I remember from law school class. I'm pretty confident that if I was analyzing the question myself, that he was talking about claims that were outside of getting your money back. For example, I've had about 4 months of no fucking sleep, and I've neglected my children once or twice because I've been so worried about that. Not because I don't care about my children, because I'm worried about getting my money back. And I deserve something back from that, from everything I've been through, and so does everybody else listen to. So there are claims outside. I don't think, I guess they know, maybe they're denying it. I don't know if Alex and company understand the barrage of legal claims that are going to come their way the second they're out of Chapter 11. And maybe that's why, maybe they do know that. Maybe that's why they're delaying this, because there are claims that are going to be made that have absolutely nothing to do on their face with just the money. It's all the emotional and physical damage that they've caused people. So I'm pretty confident, again, ask an attorney, I'm pretty confident that's what David was talking about. Sorry to jump in, Mary, I just wanted to help.
No. I truly appreciate that, Daylong. Please do, because I'm not I'm not an expert in anything here. The only thing I'm trying to help out is to kind of move people on and off the stage. So please, if you have something to interject in here that is of value, please do so. I appreciate you, Daylong. And
Thank you, Mary.
Some sleep. Don't, please try to get some sleep.
It's just that what's frustrating to me. I'm a vet. Can I vent for a second here?
As long as you don't say like really bad words or
I usually do, but I won't this time because I respect you. Imagine having totally the American dream times about 5, and the market crashes, but I'm used to that because I've been in this game for almost a decade now. So I'm used to the ebb and flows of this. I never lived above my means, but imagine having a massive 8-figure sum of money and being a single man. I have children, I'm divorced. Thank God for prenups. And not going out and being responsible enough not to buy a Ferrari, not to buy a Lamborghini. You want to do that eventually, but you want to do it when it's so small amount of money that it's no big deal. And then, oh, by the way, we're going to take a ton of it because we were silly with it. Now, I'm saying this out loud, and I know it's a blessing because I'm not out on the street. I have a lot of money outside of it, so I got to put that into perspective too. But if I'm frustrated and my lifestyle hasn't changed, imagine the person that had every nickel in the world at Celsius. So I pray for you guys. I admit it, I'm greedy. I pray for myself, but I'm praying for the people. And every single time I've talked to anybody, not on these spaces, I've said, hey, the people in high places, on my word of honor, I've said this. The people, if you have less than $15,000, $20,000 on Celsius, you should be able to move that money immediately, because those are the people that need it most. I can wait 3 years to get all my money back. I can probably wait longer than that. I don't want to, but I will. I want the people that have all of their money back immediately. And I swear on my honor as a Marine, I have made that argument. If you have $15,000, $20,000 or less on Celsius, you should be able to get your money back immediately before anybody else does. That's my piece. That's my story, and I'm sticking to it. This is the 4th time I've been on today, so I promise I won't come in again.
No, Daylong. Well, first of all, thank you for your service. Really appreciate you. First for your service to this country, and thank you so much for coming on here. And because I think when people come up here, when you're not afraid to come up and just speak, everybody deserves to have a voice. And sometimes you telling your story helps you through something. Might help you get through this situation that we're all in together. So hopefully we'll have a positive income and outcome rather. And
I'll take a positive income too. That's good.
I'm a half glass full kind of girl. So I'm hoping that this is going to make us better than we were before. I'm trying to see the positive in it. So I hope everybody else does too. So thank you so much for all you do, Daylong.
Thank you. And I promise as soon as Elon restores my real account, everybody will know it.
We'll have a party. Okay, so now I think I have, who did I have? I think I have Buffalo Tea, Buffalo Tea. I don't know if I'm saying that right. Buffalo Tea, did you want to talk? Okay, I guess not. Then I have Munch. I think you already went, right, Munch? Yep.
Yeah, I did. Thank you for answering my questions.
And thanks for coming up. I'm glad, your first time coming up, so really appreciate that. So, Next, I think, it looks like I'm gonna have to bring somebody up in a minute. Ken, and he's connecting. Or they are connecting, or maybe not. Okay, not. Clancy?
Yeah, no, if it's just once everyone's had a chance to speak, the one to speak, I don't have anything really to add at this point. We've been going for a while, so I don't know if Celsius Loans had anything to say or any, yeah, like you said, like I said, Mary, if everyone's already had a chance to speak, then maybe we should just wrap it out.
Yeah, I don't have anyone wanting to come up stage, but thank you everybody so much for being patient. I know everybody was holding up their hands for a really long time. Really appreciate that. And we're in this together. Let's get out of this positively together. That's for sure. So thank you.
Thanks for co-hosting. Yeah, thanks Mary for co-hosting today. Appreciate that. And thanks for everyone for joining. I know it's a long, I'm not sure how many people were actually listening to the hearing as well, but it's definitely a long day of hearing / listening to all of us ramble on Twitter Spaces. So I just want to continue to do these calls after the hearing, just to give everyone a voice that doesn't get a chance to talk during the hearing or doesn't listen in, to try and understand what's going on, right? There's going to continue to be these hearings that'll come up every 2 or 3 weeks, and I'll do my absolute best. I'm traveling right now, but yeah, I know these are important, and we'll do our absolute best to, as a group, to host these, and then everyone can kind of share their viewpoints. Even though this is getting this process has been months and it's frustrating for all of us, I think, like I said, it's just, and I'm guilty of this sometimes too, because I get emotional, of course, but yeah, we really just need to somehow figure out, and Simon is a pretty level-headed guy, so that helps, but just understand that there is an end in sight. There are positive things that are occurring here. It's just like, can we, stay together as much as possible and focus on the actionable things that can actually get us out of this, instead of, letting it go in the other direction. So thanks everyone.